May I please, Lordships?
Yes.
Lordships, I beg to mention item number 1 on
Hmm.
behalf of petitioner's leading counsel, Advocate N. Rama, who is out of station. Lordships. Item number 1.
What is there?
It's about misappropriation of
challenging
public
the-
money.
You are challenging the award of the work,
Yes,
the
Lordship.
contract.
Yes.
Who are you?
I'm petitioner. Lordship, I'm contractor of the said.
You are a proxy contractor.
Yes, Lordship.
Anyway, when?
After puja break, Lordship. Summer break. After summer break.
On the prayer of Mr.
Ita.
Learned Counsel appearing on behalf of Mr. N. Rama. On the ground of Mr. N. Rama. The arguing counsel, Mr. N. Rama, has some personal difficulty. This matter after 6 weeks. 6 weeks. 6 weeks.
Yes. Obliged.
Let me mention item number 9. But as per the last order, I am directed to file additional affidavit to bring certain documents which has not been made as part of the document. So at this stage, may I pray the 2 weeks time?
The selection process is over.
My lord, over.
Appointment, everything.
Yes.
Where is for the appellant? Madam, what remains? You yourself has participated also in the next advertisement.
That second selection process, since the last more than 2 years, other than the filling of applications, it has not been proceeded with till now. So far as my instruction goes.
Subsequent advertisement.
Subsequent advertisement.
Subsequent
Yes,
advertisement.
yes.
It has not been completed.
Not yet.
Not at all,
conducted
Lordship, proceeded.
yet. After taking decision by the ministry, it is not yet conducted, Malad. Process is not complete. Only he sees one of the candidate for the post, Malad.
What do you
Lordship, since they are saying they'll file the affidavit, actually it is because the learned single judge, while passing the order, took note of certain correspondence which was not furnished to me.
Okay.
So therefore, I made a prayer before this honorable court that may be furnished to me. So that is why they were directed to file this affidavit. Now, since it's been quite some time, a date may be fixed so that if they do not file on that next, that hearing may be done. Actually, it would have been in my interest if they had filed the affidavit.
How much time?
After break, Malad. 25th one.
On the prayer of Mr.
Honor before 25th will file.
M. Kato learned DSGI and prayer not being objected to by MSN Learned Counsel for the appellant. List this matter after 3 weeks.
Lordship,
4 weeks, 3 weeks.
certain date 31 maybe.
Malad, we are the respondent, Malad.
Since they are saying they'll file by 25th, 31 July.
On 31 July.
Yes,
Ah.
they are saying they'll file by
On
25th.
31.
Obliged.
DPW.
Your Lordship, I beg to mention item number 10. Leading counsel is out of station. Kindly make a
Item number 10.
Yes, Your Lordship.
I think who is leading counsel?
Yes, Your Lordship.
Huh?
Yes, Your Lordship.
Huh?
I did not.
Who is leading counsel?
Jyoti Jonglojo.
We don't see her in the court.
No, Your Lordship.
Never, we have never seen, especially this court, never seen her. Item 10. Yes.
The last order. The last order is on my case, C. Joshi. Actually, it should have been C. Joshi. I am C. Joshi. The date has been taken on my basis. I can object to the honorable court. However, on today I have not been engaged, so I cannot submit before the court. That may be recorded in the order.
So you are no longer in the case.
no longer.
You are for?
I was for not to side that.
Hmm?
But I'm for not to side. Actually, on the last date of billing, I have approved
For the
Yeah.
informant.
for the
Appellant.
appellant.
Not good
Yeah.
side.
Actually, Jyoti, Santoju, me and around all other advocates, we were there. So on the last date of hearing, I was engaged. On this date, I have not been engaged. Since on the last date of hearing, I have made a statement for this court. So it is my duty to advise this court that I have not been engaged on this date, so I cannot practice. However, I will be present for this order in all fairness.
He sought that on last occasions.
I don't think the date is going to work, but at least my name could be clear, so that
What clear?
clear in the sense that he was on the last.
On one occasion, you said the other day you were there, today you are not there, though you are present here.
Your lordship, single statement was made by me, so it is my duty to apply this article. That is the-
Are you not in good terms?
I am in good terms, but on today I have not been against, so I have to mention it before the.
No, that you decide who has to appear, who is not to, I mean,
They can agree, so at
if
least,
you are together, are you associated with her?
as of now, no.
When did you disassociate yourself?
Not this associate, actually, your lordship, I have been engaged in some of the matter, so
Hmm.
I appeared before this honorable court. So it is on that basis, your lordship, I cannot submit to you.
Tell your senior, do appear sometime. Just don't fly all the time. Be grounded also sometime. All right?
Sorry.
And nowadays, you see, it's very scary. Flying is very scary. All right? On the prayer of Miss
Vaisingi.
Learned Counsel appearing on behalf of MS Jyoti Jongluju, arguing counsel in this, learned arguing counsel has some
Out of station.
out of station.
Hmm.
That cannot be a ground.
Your Lordship.
Has some personal difficulty. Let this matter be listened, and the prayer not being opposed by the, objected to by the learned PP and APP and
Legally.
it's MS Legal Aid Council, let this matter be listed after. When? 4 weeks. 4 weeks.
All right, Your Lordship.
And your lordship, I am
No, that's why I'm asking, are you you are no longer associated?
no longer.
Okay. That's why I'm asking, what's wrong?
As your lordship.
It's okay, keep it.
Please,
You may be engaged next time also.
your lordship, I won't be,
Okay, it's okay.
please.
You sort out the differences within your, within yourself.
First of all, it's that a statement was made before the court.
It's okay.
Apart from that, it's a statement that is made before the.
It's all right. It's okay.
Please.
Oblige, Your Lordship.
Matter number 2.
Your Lordship, I'm appearing on behalf of the petitioner counsel.
It's already admitted.
Okay.
It's already.
Oh, records are also.
Sorry.
Hi, Mr. Your name?
VT Guru.
BTU. You are on record.
Yes,
G Talo,
yes, Your Lordship. I'm on his behalf.
on appearing on behalf of G Talo and
Jitado.
the learned additional public prosecutor for the state of Arunachal Pradesh. It is seen from the office notes that the records are received by this court. And the service, what about service? Is it a
This-
case under POCSO?
No, the 302.
The respondent is made a party informant or not a party?
No, no.
Okay, if so and so, and records are received in the office, the registry is now directed to proceed with the preparation of the paper book. And what about the I? This is for suspension.
First IA was disposed of for a condemnation of delay.
Condonation,
Second IA is for suspension of sentence.
suspension.
Yet,
So you will file objection. What is the, so you file written objection?
verbally I will.
No, it is required, no? If this is 302 and the punishment is life.
Life.
And it is mandated under 389, you have to file.
Okay,
your-
by that time.
Okay, you're right. This is an application for suspension of sentence and the subsequent bail. This is an application filed by the petitioner for suspension of the and subsequent bail. The learned additional public prosecutor seeks some time to file his objection, the written objection. Prayer is allowed. Matter to be listed after 2 weeks. Okay, by that, in the meantime, the public prosecutor will file the objection.
Oblige, sir.
Yes. Sorry. You filed the affidavit.
I think service is not complete on few respondents, no? 1, 2, 4, 5, 6.
My lord, basically, we are on the maintainability of this PIL. The PIL is for registration of a case, madam. Whether a PIL can be maintained for registration of a case, madam. My lord, this honorable court has already decided in various occasions, my lord, that PILs for registration of criminal cases cannot be entertained. Ma'am.
Which for the petitioner?
Petitioner, he appears through VC.
Today is not there.
He is not there today.
DK does.
Here, they file a FIR. They filed
Yes, my
a
lord.
FIR.
In fact, in earlier occasion, he came with a writ petition that was withdrawn. When the writ petition was filed,
already the SIC, they have registered a case for inquiry, my lord. Now again, they have come up with this PI. That earlier writ petition was withdrawn.
It's to be done. All our respondents are represented. All the respondents. All. You have the status? Yes, ma'am.
Up-to-date status,
Not up to date. Not up to date.
which shall be placed in seal cover.
No.
There's an order on 18/6/2024. Status review.
What is to be done? My lord, we have already listed an inquiry matter, and the inquiry is going on now. And if the problem is not there, what is? All the respondents are represented. All the respondents.
I'm number 12, 15, and 16.
Hmm?
Respondent number 12, 15, and 16.
12,
15 and 16.
12, 15. And
I think 10, 11 are not represented. 10 and 11
I am
or
10.
10, okay.
I filed my affidavit now. Not appears for the judicial all over the learned council for the Mr. Swenson before all that. Are present. Mr. Who has filed the affidavit?
10. 10
I
has filed, and then we have also filed on behalf of 9 and 5, 6 and 9.
The respondents number 5, 6. 5, 6,
And 9.
9
9.
and 10 have filed their respective affidavits. Yes. List the matter after 6 weeks.
Respondent number 12 also.
Huh?
Respondent number 12 already filed.
Then 12, includes 12. 6 weeks.
All right. After 6 weeks.
But the service upon respondent number 3, 2, 3 and 4 are not completed.
Heard Mr. T.T. Taraklan counsel to the appellate. Award service report in respect of respondent number 3, 2, 3 and 4.
2, 3 and 4.
List after 4 weeks.
Grateful.
Very good. Yes.
Hmm.
My lord, I have filed. The for vacation of interim order. That I.
No, there is an order that it will be disposed of
Yes.
finally.
Yes.
Ready?
Yes. So the appellant will, if the appeal is not disposed of, my lord, lordship will consider the my lord, that was the order last one.
Yes.
How long will it take?
45 minutes.
Why?
I'll try to complete within half an hour.
I'll
But
not,
issue is only one.
I'll not take much. Only, if you issue is only one, why 45 minutes?
Then I,
This is within 5
I'll,
minutes.
I'll complete it within 15, 20 minutes.
We'll just wait. Let us take up the other matters first.
My lord.
It is good. We'll take up the other matters, and then we will come back to this, and then we'll go.
My lord, I am appearing on behalf of Mr. R. Second. My lord, this matter has been recently transferred from principal seat. My lord.
Yes.
My lord, then we don't receive our brief from Guwahati. My lord. So, my
Okay.
lord,
This matter is this writ petition is transferred from principal seat. Mr. El Nosi, learned counsel for the petitioner, submits that he is yet to receive the courts from the from where you
from council from Guwahati.
okay submits that he may be granted some time to receive the record, to obtain the records from his colleague at principal seat. Huh? Considering that matter has been recently transferred from principal seat. Come on, let this matter be listed after 3 weeks.
No, say 28th of July also, next month.
4
Because
weeks.
learned AG is appearing in this case.
4 weeks on 28/07/2025. So as to enable the learned counsel for the petitioner to obtain his records.
Always.
First, shortly, my lord, challenging the 1997 Inspector Tax and Excise rules and further amended in 2009, and then the Head Constable rules 2021. Here, my lord, what had happened is the unequals are treated as equals. For example, my lord, in inspector rules, recruitment rules, column chain, schedule chain and 11 provides that there will be a, my lord, in the meantime, sorry. Well, I'll not burden my lord.
No.
They have admitted in their affidavit, para 10 of their.
No, it's not that. I think if my memory supports me correctly, I think in collected matters,
Yes,
I had
my lord.
given
It
some
went up to
advice or
Supreme
something
Court
like
where I was part of that matter.
that. It's a collected matter,
Corrected.
isn't it?
Correct.
It was a contempt also,
Correct. There was a.
is not it?
I forgot. I apologize, my lord.
List this matter before any other appropriate match. Without one of us, minded.
Oblige.
But the appellant before lordship was the respondent.
Achha, you have filed the affidavit
My lord.
saying that it's a false one. It's not by you
Yes.
who signed the affidavit.
Before the notary, I never appeared. And we have also mentioned that if the register to be maintained mandatorily by the notary is brought, your lordship will find my signature is also not there.
No, it's okay. Now are you really pursuing the matter now?
Yes.
So according to this affidavit which they have annexed,
My lord.
is the false one.
My lord.
There's no,
That can be relied on. That is not a genuine document.
so if there's also a serious issue in that case, in a different aspect.
My lord, your lordship is
It's a
absolute-
serious matter.
My lord, your lordship is absolutely correct. Here is a case, my lord, your lordship will find in the
Notary,
pleadings.
how can he,
My lord,
I mean,
if you are-
without in the absence of the deponent, how can he?
My lord, that's what, my lord, in the, if your lordship goes to the affidavit, your lordship will find that this is not one page, one paragraph, and there is no person, no one who has identified me before the
What is
notary.
that affidavit?
My lord.
In IA?
Yes.
Page. Page number
Yes.
Page 15.
15.
One.
It will be 15.
Page 15, ma'am.
Okay. Yes.
So lordship will find that deponent is mentioned on the left hand side, signature is on the right hand side. Then notary has signed at the bottom. So unless the notary says that I know him personally, the person has to be identified by some lawyer.
No, that's why this notary is doing all this thing.
My-
Why is not, why is signing this
my lord.
without following the due process?
My lord, that is what I said, that I have never signed, I have never appeared before the notary.
In the affidavit, that's not there. The only thing that they are saying now is, my lord, he's not denying the signature as such. What he's saying is, I have not signed this before the notary. Let's just stand there.
No, they are saying that it has not, it's not, it's as per, he has not done this is a forged one.
Yes. Malab, we have taken up 2-3. First of all, we said the appellant was never there before the court also. Malab. It was the person who was not even authorized at the time who filed, so they filed that affidavit. And Vakalatnama was also filed by that person.
My lord, so far as single judge is concerned, my lord, before the honorable single judge, respondent number 5, who is the appellant before your lordship, was represented by a constituted attorney. He filed an affidavit in opposition.
No, ma'am.
Based on that, the single judge has decided after 15-20 days of the order passed here, now suddenly a plea comes that he has not done, he has, under what circumstances when all these things have taken place, it's not clear. But fact remains that my lord, the proprietor doesn't say that we have never wanted to contest this proceeding before the single judge. He is also not saying that I have not filed any writ appeal. Only signature here, signature there, affidavit, these are all technicalities. And in what background all these things have taken place.
Then, sir, your conduct is also not, I mean, not you, but the person, the proprietor. It's not clear also. It's doubtful. You'll have to explain
We have
what
explained,
circumstances, I mean, led you to do all this kind of.
my lord, the
You are rather, sir, making a submission on technicalities.
Absolute-
Where on the conduct?
my lord, yes, my lord, under what
See, maybe if you have given a power of attorney, whatever is there, so that is, it's
Yes.
okay. But why you had to, I mean, resort to all this kind of thing?
and it's very difficult for me to.
Other day you said, I mean, one day you said that I have not filed all this thing, I have not done and all those things. You just cannot take the advantage of this thing.
I don't know, my submission will be.
If you are interested, who is stopping you?
My lord, if the proprietor doesn't say that I never wanted to contest the matter before the single judge, or I have never wanted to contest the judgment passed by one single judge before the division bench, then matter would be different. Here, somebody is relying on an affidavit, then he is filing an affidavit saying that I have never appeared before the notary. Your lordships can always understand that unless this is considered to be a affidavit in the eye of law, I'll read the General Clauses Act,
It's
I'll
okay.
read the Oaths Act, the Notary There is a Supreme Court judgment also, my
You
lord.
may be correct on that line, but then the conduct is not, it's not appreciable.
Yes.
Lordship allows me just 2 minutes only, ma'am. If Lordship sees the conduct of the appellant, Lordship will find page 38, the rejoinder which we have filed in the IA, ma'am. We'll see because the Vakalatnama we couldn't see, madam. We only in the repetition, madam. There was no occasion to check Vakalatnama. We thought, madam, it was by the proprietor. When the writ appeal was filed, we took out certified copy, madam. Lordship will see one Raj Pau filed this Vakalatnama. Before learn a city.
He's a constituted attorney. We have annexed the power of
That's
attorney.
a false statement, madam. I'll show that he was not attorney also. I'll show that also.
We have annexed the power of attorney.
Now they have come up with a new document. It was never there in a petition, nor while they filed the writ appeal. That also, that document was not there. Now they are coming up with a new document saying that this is power of attorney. New document now, totally new. That was never when they filed the appeal also. And the Lordship will kindly see, I'll just take 1 minute only, page 38, madam. Of the.
In IA,
Yes,
IA.
30 years. Rejoined.
The Vakalatnama.
Yes, this is the Vakalatnama filed by the one Raj Pau before the learned single page. Kindly see. This right side. Now Lordship will kindly see in writ appeal, the alleged proprietor has signed. Vakalatnama, your Lordship may kindly see. Page 43, that's right.
Page 43.
Yes.
Lobsang Sri.
Yes. Now,
Writ
Lordship,
appeal.
no, you need not be a handwriting expert to see, when in the affidavit, in opposition, the handwriting, Lordship will kindly see page 59. Totally different, madam.
59.
Yes. Kindly see, madam, the name, how it has been written.
Lobsang Seri.
Yes. Now, Lordship will Vakalatnama, the handwriting of Vakalatnama. They do not match at all. L is total different one. G is different. Everything is different, madam.
B is and L is different.
B is a capital B, madam. So the affidavit which he has shown that he has not filed Vakalatnama, that's true, madam. This has been filed by someone else. And Lordship will make a page 65, madam. This type copy is page 66. This is the document which he, while participating in the tender, this is the undertaking he gave. What he is saying, I'll often saying, if the Lordship allows. Such and such, resident such and such, West Coming District, proprietor MS Tenzing Construction of Birang such and such, West Coming Arunachal. Hereby affirm that I have no partner and have not issued or received any power of attorney with regard to work numbers, just present work, such and such. And Lordship, last time they annex one document in their affidavit of 4th June. 64. Whereas this person joined on 12th June, posted from Anjao district. And so many documents are being manufactured. The person, the executive engineer had joined on 12th, they come up with a document certifying 74% of work is completed. On 4th June, before he even joined the place of posting. Now they have in the affidavit, the new affidavit, they have admitted that the person joined on 8th. They have showed the certificate of 4th June. The person joined on, they directed that he was take over charge on 8th, but he actually joined on 12th June. The page 60 is his taking over of charge, 12th June. Page 60.
860?
Yes, this is the person who gave certificate on 4th. He actually joined on 12th month.
Where is his joining letter?
Page 68, Annex 6.
Ah.
They handing over of the charges. After taking the charges, only he will perform his duty. And whereas they have annexed the page 64 document as a certificate by that person of dated 4th June 2020. The appellant has not come to this court with clean hands. This apparent one.
%, 74%.
Yes, so just to defeat the IA, they annex this certificate. So that they can say so much of work has been done. So the interim order should be allowed to be continued. For that purpose only they annex this document.
Okay, we'll take.
Misleading, misrepresentation, all those things are being done in this.
My lord will permit me to just show two documents, my lord. Your lordship may kindly take it as directed by your lordship, we file the additional affidavit. Your lordship may kindly take it up. And page 79 first, your lordship will see.
79.
79. Well, our additional affidavit pursuant to your lordship last direction. Page 79 of my edition.
79.
My lord.
Yes.
This is the joining report of that gentleman And this is of 7th of May. And next page, Lordship, you can see 8th of May, an order passed by superintendent engineers. Next day. Can we disbelieve all these things, man? In pursuance of government order number so dated so 6th of May 2025, see so has joined as DPIU Chayang Tajo under Rural Works Division on 7th of May 2025. He is that person who issued that 74% certificate.
Then
Now-
why you have taken the handing and taking over charges on 12th of June?
My lord, that is the $1,000,000 question. This subsequent document, whether it was necessary. My lord, all of us are aware these things are done only in a case where there is a dispute, someone is transferred, he is not handing over charge, then a higher officer has to be told that please see that the charge is handed over. Then one side, in order to take advantage that he has already joined, he prepares a document, and the document which my learned friend is showing, you'll also find the signature of this gentleman only, other person's signature is not there. Not there. Where is that?
Yes, continue.
My lord. So that is my submission. And then, my lord, Lordship will kindly have a look at now another document, page 67. Page 67, this is part of their rejoinder, lastly filed.
What is DPI 1 and 2?
I think his designation is something like he's executive engineer DPI. That is
Yes, DPI 1 Chayang Tajo, but then
Uh-huh.
in page 1.
He is the one.
Page 31, this thing, it is DPI 2, 64.
But in case of when there is several projects, this is DPI is the project implementation unit.
Yes,
So there used to be, they can designate two officer as a DPI.
so you are, he's 1 and 2.
One is, he's,
Page 64 is 2 and page huh? 80 it's 1.
68,
80.
Cheng Tajo is I think two, DPI two.
DPIU 1 Chayang Tajo.
Hmm.
Then here DPI U 2 Chayang Tajo. Page 64.
That may be typical mistake by the,
DPI only.
yes.
He's the person, my lord. DPI, he is the person. Lordship will kindly find it page 8.
No, we know he's the person,
Well-
but then what I'm asking is that
Maybe they are-
1 and 2, are you
Yeah.
for 1 or are you for 2 or both? Is he for 2 or is he for both? What
That
is-
we have to clarify. There is some. Maybe Cheng Tajo.
My lord, in any case, my lord, he did not join on 4th month. If my lord, senior says 7, 8 joining, that is showing, but this certificate is issued on 4th, my lord. That's
It's
the
June,
question.
June.
8
What
of
he's
June,
showing is May,
7th May.
7th May.
whatever, 7th or 8th May.
No, the page 64 one.
Yes, 64 is
June.
4th June and he's claiming that in the 4th May only.
Yes, 7th, 5 and 8th of
June is after May only, not the same month.
Not same.
The department, yes, that's.
7 and
Yes, my lord.
7 and 8, he said he joined on 7th May
Yes,
and the order was passed for handing over
8 June.
8 June next day and he has issued this certificate on 4th June.
Yes. 8 May, superintending engineer himself is saying that he has joined. And one document, if you lordship kindly sees my at page 67. Page 67. He says, with reference to the above cited, I am hereby inform you to kindly join us for the inspection of project, namely so on 22nd of June 2025. After inspection, a fresh progress report and certificate will be given to you. That means I have already given one, fresh I'll give. So I am hereby inform you that certificate issued to you to your wide number so on 4th of June has been cancelled. He is not saying that I have not issued. I am cancelling it. Due to mistake in typing date and wrong information in the physical progress report. It is. So he is not disputing that he has issued. If the information is wrong, physical progress report is wrong, I'll ask your lordship, I'll pray for before lordship that fresh progress report may be taken now. The merit of the case is not on that.
But we just cannot brush aside. Your conduct. Who is pursuing now?
My lord.
Attorney holder, power of attorney holder, or the proprietor?
Proprietor, my lord. Proprietor, this affidavit has been filed by the proprietor. As directed by your lordship on the last occasion that he has to clarify, he has filed this affidavit. He is duty bound to file an affidavit and clarify. And he has clarified. Lordship, you kindly see in the additional affidavit we have explained everything.
Wrong information in physical progress. Very, very.
I'll urge before your lordship, my lord, that the appeal may be taken up on merit. It's a matter of 10
No,
15
we
minutes.
just, sir, we're sorry, we will have to clear this first. It's very
My lord,
difficult.
then lordship will kindly take up my additional affidavit how the proprietor has explained, my lord. The additional affidavit filed.
Yes.
On 24th of June, my lord.
Hmm.
Lordship will kindly see paragraph 2 onwards, my lord.
Hmm.
That as already stated in the affidavit in opposition, because we already filed an affidavit in opposition, filed by page 71, running page 71. As already as already stated in the affidavit in opposition filed by the deponent on 19 June 2025, the purported affidavit dated 9/6/2025 is a fabricated document and the deponent did not appear before the notary so-and-so on 9/6/2025 or 10/6/2025 or on any other date. It is evident from the said purported affidavit that the deponent was not identified by any person or advocate as he is required for administration of oath by the notary. As a result, it is evident that the said purported affidavit is not a genuine document and therefore no reliance can be placed on such document. That the deponent states that the above mentioned purported affidavit is not an affidavit in the eye of law, inasmuch as for non-appearance of the deponent before the notary, which would be evident from the fact that in terms of the provisions of Section 8 of the Notaries Act 1952 and the provisions of Rule 11(2) of the Notaries Rules 1956, the signature of the deponent will not appear in the register in Form 16, since the deponent never appeared before the notary and the question of taking his signature in the register does not arise. The same is not an affidavit in the eye of law, because the deponent was never administered oath by the notary as per Section 139 of the Civil Procedure Code and Section 3 and 4 of the Oaths Act 1969. Accordingly, the purported affidavit being not an affidavit in the eye of law, the same may not be relied upon by the Honorable Court. The deponent states that the deponent produced the document produced by the applicant before the Honorable Court on 20th of June 2025, that the executive engineer Likwang Luang joined after 4/6/2025 and therefore he could not have issued the certificate dated 4/6/2025 about the progress of report. But in fact, Sri Luang had joined Chayang Tajo on 7th of May 2025 by submitting his joining report before the concerned superintending engineer on 7/5/2025, and after joining of the duty, the official can assume his normal duties as accordingly he has issued the said certificate. The deponent states that he executed a power of attorney on 2/12/2024, authorizing and empowering Sri Raj Pao, son of late Yade Pao, to look after the work in question and to represent, file suits, appoint pleaders, sign vakalatnama, etc. before concerned authorities on behalf of his firm in respect of the construction of
Properly paginate. Oh, yes, construction of road in question.
Yes.
See the next, in the same page,
My lord.
last
Yes.
line.
Yes, ma'am. The road in question is under the seal, my lord. That in view of the aforesaid facts and circumstances, this honorable court may be pleased not to act upon the purported affidavit and be pleased to reject interlocutory application and dispose of the writ appeal on merit for the answer.
You have not said that you have not signed the affidavit.
My lord,
You just
that is
said you have
why,
not.
why I am
you-
not
you
saying,
did not.
my lord, I think possibly they are not.
Very.
made. My lord,
Your conduct.
my lord, my signature are relying as an affidavit. If the affidavit has been procured and fabricated document, your lordship will certainly not rely on that document as an affidavit. And this thereon. And signature, as your lordship has seen, my lord, they have taken the signature on the right hand side. Deponent is mentioned on the left hand side.
Yes, where tentatively, the inquiry has to be caused. This sort of, it's an involvement of the notary also. Yes,
Yes, my lord. Lordship will kindly see the Bakaladama also. Plus, the
in that case,
signature on
in that
Bakaladama.
case, will not be able to enter in unless these things.
The affidavit signature is totally different, my lord.
That's why we cannot, we're not able to make it out. So we'll cause an inquiry.
But he is not denying that he has signed, my lord. There is no category.
Whatever.
Any of the.
Let there be an inquiry. Thereafter, we'll whether to enter into the merit or not. But in view of that, because until the things are clear,
And let the
work continue.
Work is continuing.
Works is continuing.
Yes, okay.
Otherwise, this is not a working season, road construction.
Work is continuing, my lord.
Okay, okay. You are in favor of continuing.
Yes.
But, what will happen, my lord? If the interim order is vacated, the direction of learner single judge was not that.
Materials there.
Should be awarded to me, my lord. That's not the order.
Ah,
So the order was that the price bid should be open.
why private bids should? They are already working on it.
Yes, that is the difficult part for the department. At this stage, financial bid cannot be open.
Suppose if it is open, right?
Yes.
If it is found to be, you are more, I mean, you already been awarded, what will happen?
My lord,
Can you be given the work
yes,
now?
that was made clear by the learner single judge.
That will hamper the work.
Yes.
No, my lord, that's not a work.
What is the percentage of progress?
Percentage, my lord,
Your executive said that it's wrong. It was a
Yes.
false information.
that has to
Wrong
be assessed
information.
properly
Ah,
with more officers.
hmm.
Even the executive officer sometimes this time is like this very difficult in the ground. Officers are not doing independently.
We're taking it up on next Tuesday. Let us apply our mind also. And in the meantime, you
Ascertain.
obtain instruction regarding progress of the work.
Yes.
Not involving this executive engineer.
Yes.
Let it be
Superior,
superintendent-
superior.
superior authority, chief engineer, whatever. Exact percentage of
That
progress.
some order may pass, my lord.
Third, Mr. Who is the sport appellant?
I'm for the applicant.
Okay, you are the respondent in the writ petition.
My lord.
Okay. And Mr. D. Majumdar, learned senior counsel, assisted by Mr. Learned counsel for the appellant, and Mr. You are one.
Yes.
Peter for learned counsel, respondent number one, and Gita for learned standing for RWD. After hearing the learned counsel for the parties at some length, we find that the and the perusal of the affidavits, filed by the appellant as directed by this court on pursuant to the direction of this court, dated 20/06/2025. We find that the affidavit, we find the stint of the appellant to be not clear. It is also noticed that the progress of work shown to be 75% by the executive engineer has also been recalled on the ground that the information was incorrectly furnished. in view of the above, let this matter be listed on Tuesday next, which date? You could, Tuesday,
Can it be on Wednesday, man, second one?
why,
Malat,
Wednesday?
I'll be out of station, man.
Even I'm also likely to be out. Thursday is better. Second, I'm coming back. Subject to
Second we
adoption.
can have.
Third.
Second week.
Second, I'm coming.
Third.
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 Yeah.
Third is Thursday,
Yes.
Thursday.
Yes.
Third, okay. On the next, Mr. Jeter, the standing council shall, please. No, Mr. Jeter, land standing council obtain instructions as regards the progress of the work from the departmental authority. That is which would be from the superior authority, then the executive engineer.
My lordship may kindly mention the name of the officer so that they are not.
Superintendent,
Superintendent.
superintending engineer. Huh? We're not happy.
Certainly,
things-
my
the things
lord. I
have
am
been-
for the first time faced with something. I would know. In fact,
We're also.
I did not like to appear
Yes.
with this, my lord. I do not want to appear in a case. Very
And
frankly
when
speaking,
all of us should not.
I have not appeared in a case in my.
Moment, all of us should not encourage such type of thing.
Absolutely, man.
It has
Absolutely.
to be.
My lord, I am
wiped out.
personally, my lord.
Would have
I'm
to be erased. out.
Every moment I am thinking, I'm
Yes.
asking my learned friend that please relieve
See-
me from all these
See,
things.
sir, look at this. You assist us, all of you. These things one way.
Very
I mean,
difficult, man. Very difficult.
if
And
you-
very embarrassing. I should say, man, it's very embarrassing for me also.
It
I
should
do
be-
not
it
want to
should-
enter into
It
this.
should be one isolated cases. If we don't
Very unfortunate.
stop here, I mean, it's very difficult.
And very, I should say, man, very embarrassing for me also.
You have read the affidavit. Sir, you have read the affidavit.
I have read the affidavit. I have read
I
the document.
understand,
I have
but
there are many things, man, all of us understand, but
we
it is
would like
difficult
to,
to
in
discuss
such a
inside.
situation, we'd like to request you, all of you, to
Right.
rise above your brief.
Mine.
That we will look up to you
Absolutely.
as a senior, designated senior.
I'll try to assist.
I request all of you to rise above your brief in such cases. It's for the, I mean,
Institution.
interest of the institution
Mine.
as well as for the litigants. All right. And then you see, the notary has been established recently, I mean, a lot in the state. When you started all these things, he may be in trouble also if you take it. I mean, let us see this notary.
And on the one hand, this is like this. On the other hand, my lord, notary is a junior counsel. Nobody wants to
No, they should understand.
spoil his career. We at least don't.
That's what I'm saying. That's what I'm saying.
That is the difficulty. He's a new junior. He has started his profession, notary practice. Why should we come in the way, man?
They should understand.
My
Please, Your Lordship,
Yes,
I beg to mention item 9, Lordship.
9.
Here, Lordship, I am for the respondent.
Number
3. Lordship, this is a very long matter. I have, sorry to say, not very well prepared. Can this be taken up some other time, Lordship? Writ petition is by the state.
By the state.
Yes.
Okay, on the prayer of MS Ed Daggett, learned counsel for the respondents.
Respondent number 3.
Respondent number 3. List this matter. Prayer not being objected to by Mr. N. Ratan, learned additional advocate general for the petition. List this matter after
After 2 weeks, Lordship.
2 weeks.
Interim order is there
Okay.
in their favor.
Interim order is there.
Yeah.
What sort of interim order?
The order of the micro and small enterprise the council has been,
Then what is there?
there is an award for
They're
payment of.
challenging the jurisdiction of the micro and small enterprise facilitation council, which was in my favor.
Okay. Interim order passed. Alias will continue.
All right.
Until further order,
Huh?
until further orders, ma'am.
This until further order, so what? Huh?
No, ma'am. Till the returnable debt.
It was still returnable debt.
Still return. Continue. We'll continue.
All right.
Okay.
May I please, Your Lordship? Your Lordship, in item number 26, Your Honor, I'm
Hmm.
appearing for the petitioner. So
Yeah.
there is a instruction for withdrawal also. I may be allowed to withdraw. Item
With-
number 26.
Withdraw.
Yes, Your Lordship.
On the Mr.
N. Kakum,
Katun,
N. Kakum.
N. Kaku. Your name is not there.
I'm appearing on behalf of AK Singh, Mr. Conducting Counsel.
Appearing on behalf of Mr. A.K. Singh,
Yes, Your Lordship.
Land Council, but submits that he has an instruction to withdraw
Yes, Your Lordship.
or had become in process.
Withdrawal.
And an instruction to withdraw this writ petition. Please to MS G. Learned Senior Government Advocate. Additional Senior Government Advocate is present. Prayer is allowed. Mr. Accordingly, writ petition stands closed on withdrawal.
Briefly, Your Lordship.
May I please, Lordship?
Yes.
Lordship, I put three.
Ah.
Lordship, I'm at number 6 to 12.
Hmm.
Lordship, I pray for seeking 3 weeks time for filing my affidavit.
Okay.
I have
On the
taken-
prayer of Mr. T. Tabala, council for the respond number 6 to 12.
Private respondent
Let's
after 3 weeks.
this matter after 3 weeks. In the meantime, so as to enable him to file
I have
affidavit
obtained
in.
consent from the other side. April.
So as to enable him to file affidavit in office.
Lordship, I would like to mention item number 20, Your Lordship.
Who is it?
Lordship, here we have to file affidavit, Your Lordship. Some time may be given, Your Lordship.
Hmm. Further, 3 weeks time is granted to MS R. Basar London State Council for the respondents to file the response.
Lordship.
Mr. D. Laji, London Council, but the petition is present.
All right.
Lordship, I would like to mention item number 19.
Hmm.
2 weeks time will be given to file an affidavit in opposition.
You are for respondent.
Yes, Lordship.
Same order, Mr. So and so is granted, for the two so and so. List after 3 weeks.
Myself.
My Lordship. My Lordship. Lordship, I beg to mention item number 17.
17.
Yes, Lordship.
Yes.
Here I'm appearing on behalf of Senior Standing Council, Tabatagum, Lordship.
Hmm?
Tabatagum, Lordship.
Yes.
Health Department.
Okay. What do you want?
Lordship, now matter picks after 3 weeks.
Mr. So and so. No, on the prayer of Mr. So and so, Land Council appearing on behalf of Mr. T. Tagum, Land Standing Council for Health Department. List this matter after 3 weeks.
Deeply obliged, Lordship.
Please, Your Lordship.
Yes.
Your Lordship, I beg to mention WPC number 205 of 2025 for listing it tomorrow.
Why?
Tomorrow.
What is the urgency?
And in this case, I would like to make submissions with regard to the interim prayer. The last date, what was challenged?
When it was listed?
It was last listed on 27th, pardon me, the 13th of May 2025.
Okay, we'll see.
Lordship, this read is regarding the illegal appointment of.
Who are you?
Yes, Your Lordship.
Who are you?
I'm petitioner, Your Lordship.
You know, what is your profession?
I'm a government
Are
employee.
you
Your Lordship.
eligible for assistant professor?
No, Your Lordship, this co-guarantor read is.
You are
this
a
can-
government employee.
Yes, Your Lordship.
Which department?
I'm working as UDC under PWD department.
Will direct the department to initiate proceedings against you. How you can file such type of petition?
Lordship, this read can be filed
Not at
co-guarantor.
all. What is your locus? You are challenging the appointment of professor,
Yes,
or
Your-
assistant professor.
yes, Your Lordship.
Are you eligible to be are you qualified to be a professor or assistant professor? How can you file like
Not
this?
so, Your Lordship, but co-guarantor read can be irrespective.
What do you mean
filed
by
by-
co-guarantor? Who are you? That's why I'm asking. What is your locus?
Your Lordship, this similar nature of
Are you what similar nature?
the read is already pending before the Honorable Court, Your Lordship.
Where?
Here only, Your Lordship. Before-
We'll list along with that tomorrow. It's not maintainable. You are working as a UDC. Are you qualified to be considered for appointment as a assistant professor?
No, Your Lordship, but it's locus
Huh?
standi for the filing read petition co-guarantor is not required, Your Lordship. Any person can be filed.
Go around to quash the illegal appointment. Respond number 4. To conduct a fresh selection process. Are you eligible? Are you qualified person?
No, Your Lordship, I'm not, but this is indirectly or directly.
How you are
affected.
how you are affected?
But it is for larger interest, Your Lordship.
Hmm?
It is for larger interest, Your Lordship.
You file a PIL if it's for larger interest. Be serious and sincere to your job, not all kind of districts.
Your Lordship, may it be fixed or some other day so that I can please the Honorable Court with. I want to make some more submission, Your Lordship, if I.
Make your submission.
Lordship, this in read petition co-guarantor, any person who is a citizen of India or any irrespective of any interest, he can file co-guarantor, Your Lordship.
Hmm.
Any person irrespective of irrespectively it can be filed.
That's all.
The PIL is certain matter, madam. But madam, yes, he has rightly pointed out, one matter is also pending. Pertaining to madam, the appointment of the madam, the employees of the NIT, madam, NIT Jotem. That madam, in that case, madam, the notice has been issued. By the judge. Admittedly, madam, this is not maintainable, but however, madam, the notice has been issued in that matter, madam.
Heard Mr. Swain learned counsel for the petition, huh? And Mr. Learned DSJ.
For
List
respondent number
along-
one only.
List along with WPC.
I don't remember, Your Lordship.
You will find out and give the number.
Yes,
Huh?
Your Lordship.
We'll take it up
I
the
think same person. Only the read number.
same
petition.
person.
Yes, madam.
No, Your Lordship, that respondent number 4 is different, but this is regarding NIT only, Your Lordship.
But same person, same petitioner.
Same petition.
Yes, Your Lordship. Same.
What is your interest? Why you are after the NIT?
Even if his case is considered, he is not qualified.
Any affidavit file in that case?
No, madam. Only notice has been issued, madam. Madam, only difficulty is the NIT Jote have their own standing counsel, madam.
I am not inclined to even issue notice. Just because there is other similar method pending, so I'm just
Then-
list along with it.
Day
Next
after
time you prepare.
Yes, Your Lordship.
Day after tomorrow, madam.
No, it should be listed along with those. I don't want to,
Yes, madam.
as a young lawyer,
That was
I
the
don't
observation made.
want to break his heart.
Madam. Exactly, it is PIL in service matter.
We'll just, it's not a PL.
Form of-
Go,
Form of PIL.
list along with it.
Deeply.
Much obliged.
Made to the.
Can I take up this matter?
I'm not aware of any.
Yes. Where is Mr. Sekia? Yes. Can I take up this matter? This hydropower,
Hydropower. Ready.
seniority,
Yes.
seniority dispute.
Seniority dispute in other cases, here, my lord, parallel proceedings have been started, my lord. Where the same subject matter is subject before lordships.
Let them find out what's there, who is what exactly.
My lord,
Is there any interim order
there,
in the other?
no, my lord,
Proceedings.
pleadings are complete, my lord.
Yeah.
The petition was based on the recommendation of a subcommittee.
Hmm.
That was not in fact accepted by the government themselves. Now they have constituted a committee
See
again.
the respondent.
Dominated Vijay Pasan.
Ah,
So I'm sure that.
No, those.
I have no idea, man.
Yimiyango and all those.
Imiyago, they are not here, madam.
Yimiyango is
No.
not there.
The Tominate is here, madam.
But I never had a, did I appear in those?
I am not so sure, madam. But in one case, madam, Dharma Ete and Tominate, they came before this honorable court, madam. Let him take up my lord.
Dharmarate, Dominate cases are pending. They are taken together
Ah,
in the other cases.
ah.
Dharmarate is there.
Can I take up that?
I have no idea.
I will check it up, madam, and inform this court, madam.
Let us see tomorrow.
Tomorrow.
You kindly find out.
Yes.
I will inform him.
Because I'm not also sure.
Yes.
If it is not connected, there's no, I mean,
Yes.
issue, but if even a
Yes.
slightest connection may have. Tomorrow, huh? List the matter, tomorrow.
Tomorrow.
Heard so and so, huh? List the matter
Tomorrow.
tomorrow.
Well, this challenging the impugned loss assessment
Hmm.
by the respondent number 3 and 4
Hmm.
without visiting the field and passing it behind my back, my lord.
Hmm.
So there was a land dispute between the Neelam party and the private respondent
Hmm.
in 02 area. The LPC was put into challenge.
Hmm.
Then they also filed a read petition, my lord. We
Hmm.
also filed a read petition
Hmm.
on the ground that the cancellation of the private respondent LPC was dehoused the established procedure. That is, he was not afforded the opportunity of being heard. So thereafter, my lord, what had happened was, then it was referred to the, they filed one title suit. The title suit is in, what is this case number?
Evidence.
Title suit is at the stage of evidence. Now, therefore, my lord, here the government the LRSO has also admitted the impugned loss assessment report dated 29/3/2022, which stands at page 47, my lord, was done behind the back of the petitioners.
Hmm.
So therefore, my simple prayer is, without visiting the field, you cannot do this. And this has been admitted by the affidavit of respondent number 2, my lord, at para 10.
Hmm.
Para 3, page 10 and 11, my lord. There's a small case, my lord.
Where is the impugn order?
Impugn order is at page 45, my lord.
45.
What had happened was, my lord, 28, 28/3, the deputy commissioner passes another impugn order directing them to make the field assessment. And next day, without visiting the field, my lord, they have passed this, done the loss assessment on the basis of the FIR.
You have damaged, you have caused the damage. You have destroyed.
But no, there is a dispute,
No, allegation of damage.
allegation of the damage, my lord.
What is the
That,
assessment? Where it is?
page 45, my lord.
No, this is only.
Without visiting, my lord, the field, they have passed it. My lord will see first, my lord will see page 44.
Where's what? No, this is the assessment report.
No, my lord.
Where is the order to? Is there any order
Yes,
to
yes,
make
my lord.
payment?
That's page 44, my lord.
44.
Page 44. This is the order directed by the deputy commissioner,
Hmm.
28 March, my lord. The order says, my lord, DC0 approval stroke directions, Sri Komi Murtam, DHO 0, and Srimati Taso Yalu, DHOD Yachule, are hereby directed and engaged to prepare loss assessment of Agri Horti Garden of so-and-so Yoglu village of Lower Subansiri district, basing upon the final report of investigation officer White 0 PS case number so-and-so. The officer shall furnish the report to applicant after completion of the loss assessment for further necessary action from this end.
Hmm.
Now, my lord has seen this letter was, this order, impugn order was issued by deputy commissioner on 28, and very next day, my lord, without visiting the field, the loss assessment report was prepared, my lord.
How do you know?
Kindly see this. In the government affidavit is also very clear. They have justified.
Saying what?
Saying that, yes, on the basis of the
Loss assessment damage.
yes, was done on the basis of the charge sheet filed by the 0 PS, officer in charge of the 0 police station. No, page 46, Lalin.
Hmm.
So therefore, Milan, whatever it is, behind my back, this has been passed, and kindly see the affidavit in opposition of the respondent number 2, dealer also.
Hmm. So the title is still pending.
Pending,
Title
let
suit
them,
is
whatever
pending.
they do, Milan.
Title suit is pending.
Let them do.
But then allegation is that you damaged and destroyed
correct. There is a criminal
horticulture
case.
and other thing.
There are criminal
Agriculture
cases.
and horticulture.
Correct, my lord.
So criminal case, what about the criminal case?
Criminal case, I don't know if this, he is conducting, my
It
brother
is-
Tama is conducting.
No, actually, that is also in progress. I think 3 or 3.
You want to. It's a trial.
Otherwise,
Trial on.
this is not a factual correct position.
No,
which
we'll
my
come to-
brother
we'll-
is
we'll come to you.
explaining.
We'll come to you.
No,
Let us
see-
have some patience.
My lord, I am not quarreling anything on the title.
Yes,
suit or the
respondent
FI.
number 2. Yes.
Page 10, my lord, paragraph 3.
Hmm.
That with regards to the statement made in paragraph 1 and 2 of the writ petition, the answering, the opponent begs to state that as per the record, the loss assessment report dated 29/3/2022 was prepared and submitted by the respondent number 4 and 5 on the basis of application dated 25/2/2022 submitted by the private respondent on the FIR dated 27/5/2019 and charge sheet number so and so submitted by the investigating officer of the case.
Hmm.
Thereby, my lord, any loss assessment, you must visit the field. Whether there was a disruption of your visit or not, you have a police force, you have a machinery with you. You cannot do this assessment on without sitting in the comfort chair of a AC room. You cannot. If you are tasked with a duty to perform in a particular manner, you perform, otherwise you perish it. This is, they have also admitted, my lord. Even my lord will kindly see paragraph 6 also of the affidavit in opposition.
Hmm.
He said that with regards to the statement made in paragraph 7 of the writ petition, the answering deponent begs to state that prior to passing of the order dated so and so by the civil judge senior division 0, the respondent authority had already exhausted to carry out assessment of the property's damage on several occasions, but that could not have been done due to mass protest from people of Neelam village. Thus, there was no chance for assessing the place of occurrence, I think it should not be occasion, my lord, place of occurrence for assessment. Even if the board of experts could have been constituted for the same, hence the loss assessment report dated 29/03/2022 was prepared by the respondent number 4 and 5 basing on the charge sheet number so and so submitted by the investigating officer. Now, how this can be permitted? At least you should make an attempt. And even further, my lord, respondent number 4 and 5, who prepared that impugned loss assessment report, have also admitted, my lord, that yes, we have not gone to the field and we have prepared on the basis of the charge sheet filed by the IO. My lord, kindly come to paragraph 5 of the respondent number 4 and 5.
Who is 4 and 5?
The district horticulture officer.
Hmm.
And the SDO who prepared the earlier impugned
Where
loss
it is?
assessment report.
Page
185.
185.
Yes. Now there is a new notification that it should be in continuation of pagination should be in continuation to the rate petitions and all that.
Yes.
It says that with regard to the statement made in paragraph 8, 9, 10, and 11 of the petition, the answering respondent begs to submit that as per record application dated 25/2/2022, annexure 4 of the petition, submitted by the private respondent to the Deputy Commissioner 0, was being endorsed to the answering deponent authority on 03/03/2022 for needful as prayed by the private respondent, which was being replied by the answering respondent authority, annexure 5, indicate Motley. 5 series of the writ petition, informing about the inability to calculate the damages without conducting verification.
Yes.
So, my lord,
Your only case is that assessment ought to have been done
in the
by physically visiting the place of occurrence.
correct, my lord.
And the damages caused, right?
Right, my lord. My lord, kindly see
Yes.
the same principle.
Now, suppose if we find that it was not correctly done, should have been. Now, what to do? Now, after 4 years, 2 years, can you direct them to have a reassessment?
That is, my lord,
By now, much water has already flown.
my lord, rightly or the wrongly, whatever, the action of the respondent authority is equally deprecable. At least you should have made an endeavor to visit the field with the police force. And my lord, kindly see, in their LPC, when they have challenged, their LPC was cancelled. My lord will kindly come to page 23.
But the deputy commissioner has filed an affidavit. Deputy commissioner.
Deputy commissioner is made.
Yes. What is stand of the deputy commissioner?
As stated in our directives, several attempts have been made, you know, to
For what?
carry out the, but due to protests from the village.
So your officer who has made an assessment saying was pleased to direct the answer him to simply assess as per the charge sheet. Charge sheet is not a. Hmm?
Officer, you know, there was a final report by request. Sir. Due to protest, we could not be lodged as the.
That's the only ground.
Yes.
So you have directed them to based on the charge sheet. Yeah.
My lord, I will not further make any submissions. I request my lord kindly come to page 23. The common judgment and order, the principle laid down in this, the common order is applicable in this case, where my brother Tama has also appeared in this case. My lord. Page 23, my lord. There's a 12/2/2020 order.
23?
Page 23 of my read petition.
Read petition.
Yes. Fact, my lord, I need not to read, my lord. The ground was, my lord, kindly come to page 24, para 6, I'll read. Thereafter, I'll not make any submissions. Considering, para 6, on considering the submission made by
Yes,
counsel.
wait. Cancelling the land possession certificate
correct.
issued to the petitioner.
Which I referred to earlier. It was also passed behind the back without giving an opportunity to them. So therefore, this honorable court finds at paragraph 6, next page, 24. Para 6, my lord, has seen. Or may I assist, my lord, reading out?
I am ready.
Yes, thank you, my lord.
It was found to be no notice was given,
Same
which
thing,
violates the principle of.
same thing here, my lord. 28, the deputy commissioner, 28/3, 2022, deputy commissioner directs them. Then on 29, without visiting the field and giving notice to us, loss assessment were prepared and submitted on the same day, 29. They're kind of how that rocket science was invoked in this case.
It's not a rocket science. It's based on the charge sheet.
That cannot be. The IO is biased. How his report can be taken on face value? All his report, my lord, in a criminal case
It's not
would
a base
only be
value.
a corroboration.
Based on charge sheet. Charge sheet.
Charge sheet, my lord, whatever they have submitted, or the charge sheet filed by the IO is only is not a substantive piece of evidence. So therefore, that cannot be relied on. Now, my submission is that.
Are you on trial? Are we on trial?
No, my lord. Just
Then-
I'm referring to, because my lord was saying, referring to that on the basis of charge sheet filed by the IO.
No, this is what the affidavit says,
Correct.
which supports you.
Correct. No, my lord.
Which
My lord is
supports
very
your
correct.
case.
Correct, but I bowed out, my lord. So therefore, my lord, I will not make any further submission, my lord, on this basis, my lord.
And I think that it is not required also.
Yes.
No further submission is also
No,
required.
not required.
Yes.
May I please, my lord. Actually, my lord, what happened?
Prime facie it appears to be on the basis of charge sheet only.
Charge sheet only.
No real assessment.
Because my lord, the
No
authority,
actual assessment.
authority, my lord,
It's
were
wrong.
not
It should not
left
happen.
with any other option.
Hmm.
Because what happened? Some material fact also it is suppressed in this writ petition.
Hmm.
Had it been in the writ petition, every facts it was stated, like initially.
Just wait. Mr. Tara,
My lord.
apart from this, are you conceding that you have damaged, you have caused and damaged?
We are disputing, that is subject matter of trial.
Hmm.
We said we have not caused
That
anything.
money should, basing on this which we have filed, is under stay by this honorable court.
Ah.
So in that case also, they can take that recourse while cross-examining
You have filed a money suit.
basing on this assessment report,
Assessment.
we have filed a money issue.
Then
This honorable court has stated money should also.
okay. You want to remove the foundation by this writ petition.
That is correctly understood.
It's listed. It's listed. I mean, it's pending.
Last time, your lordship, it was, both of
Civil
us,
writ.
we argued there also.
Civil
Okay.
records. No, my lord, here, see.
Now,
why-
we have
why-
segregated this matter.
Yes.
Ah.
No, brother.
Did we segregate this matter?
No, my lord. We never.
It was not listed
No,
together.
not.
We list along with that.
My lord, as far as my brother Tama's submission,
Hmm.
to the ground that I have suppressed the material fact, I have not suppressed anything.
Hmm.
Our only challenge.
No,
is,
he has not said so.
No, he submitted just a while.
Let me complete.
Yes, our challenge basically is to this impugned loss assessment report only, my lord. Nothing else.
The
is
basis
there.
of the basis of money suit is this, right?
Yes.
Correct. Subsequently, they have filed.
Yes, we'll hear him.
Yes.
Initially, my lord, what happened on 27/5/2019, these petitioners, along with some other person, they have been to my garden and they have caused damage.
No, sir, it's a matter of trial now.
Thereafter, my lord,
Subject matter.
we have lodged the FIR and we have written to the deputy commissioner for loss assessment. Then first loss assessment that was ordered on my lord 6 June 2019 by the deputy commissioner by constituting some officers as a committee.
6 June.
6 June 2019. When they have attempted to assess the loss, all of a sudden, including these petitioners, some villagers, they have protested. They have not allowed the officers to go and physically assess the loss. That was the first attempt. And that was covered in the media also, wherein some villagers, they have said that we will not abide by the order of the deputy commissioner. If you can,
Where the administration is so helpless.
my lord, thereafter, my lord, what happened? Then we approached by way of filing title suit. In that title suit, same title suit, my lord, I have filed another application for mandatory injunction. Considering all those aspects, the learned civil judge, senior division 0, has passed an ad interim mandatory injunction, thereby directing kindly come to face, my lord, these things are suppressed, my lord. And had it been this were, had this were known,
Page,
my lord. It start from page number 97, my lord, of
your affidavit.
my affidavit. 97, but then the operative portion is at page number 104.
97.
It start from 97 onwards.
Yes.
Kindly come to page 104, the operative portion. Paragraph 16, in view of the above discussion, the following order is passed. A commission is hereby issued and the Deputy Commissioner Lower Subansiri 0 is directed to constitute a board of experts to carry out technical assessment of the properties damaged on 27/5/2019 in the suit land. The commission shall submit its report within 3 weeks from today. However, in the interest of justice, it is directed that board shall give notice to the respondents dependent and allow them to participate during the process of assessment in order not to cause any prejudice to them. B, the respondent dependents are directed not to obstruct the applicant and her laborers from entering into the suit land so as to allow them to pluck, harvest the tea leaves and kiwi in the suit land. The respondent dependents are directed restrained not to alienate and alter the status of suit land by cutting down or plantation or by making press plantation in the suit land in any form or manner. Issue notice to the respondent. And then I was directed to take steps in terms of Order 39 Rule 3. So this order, my lord, it was passed on 13/11/2019. First attempt, my lord, that order of Deputy Commissioner for loss assessment in the month of June, that was failed because of these petitioners. And second, this direction it was issued. Thereafter, my lord, next page 105. In continuation to earlier letter number so and miss case number 1, so dated actually the 13th circle officer prisoner along with board members consisting of mentioned below officers are hereby directed to carry out assessment of properties at Panya with effect from 23rd December. Thereafter board it was constituted, my lord, and direction was issued to carry out the assessment of the property damage, my lord. Page 106, my lord. These are again, along with these petitioners, some villagers, they have obstructed. They have not allowed the officers to visit the field. This is the second attempt. And thereafter, this report has come, my lord. Kindly come to page. Kindly come to page 126, my lord. This was in the same miss case wherein that order was passed by learned civil judge senior division. This order is of 15/1/2020, my lord. Operative portion, my lord. Page 127, second paragraph onwards. Now, herein referring to the first order, my lord, which I read out earlier. By the order dated 13/11/2019, this court had issued a commission directing the Deputy Commissioner Lower Subansiri District 0 to constitute a board of experts to carry out technical assessment of the properties illegally damaged on 27/5/2019 in the suit land and submit report within 3 weeks. The Deputy Commissioner Lower Subansiri District 0 has submitted a report by number so and so dated 13/1/2020. In the report, it is stated that in compliance of order dated 13/11/2019 passed by this court, a board was constituted for technical assessment by number so and so dated 26/11/2019 with ADC actually as a chairman. Thereafter, ADC actually reconstituted a board by number so and so dated actually the so and so dated 13/12 for damage assessment. The board so constituted submitted report on 24/12/2019 that the board reached Panya and Nilam village on 23/12/2019 to carry out the loss assessment. But the public of Nilam village stopped and get out the assessment team. The mob armed with daws, lati, iron rod, etc. obstructed and threatened the team from making assessment and also shouted unparliamentary words upon the team due to which the assessment could not be carried out. Thereafter, on 7/1/2020, the plaintiff and dependent were called for meeting in the chamber of the Deputy Commissioner 0, where some some to the dependents attended, but plaintiff Srimati Likha and Sri Likha sir did not attend. In the report, it is also stated that the dependents insisted on the presence of the plaintiffs and Sri so and so, and told the meeting that without their presence, there shall be no solution, including allowing of assessment. The Deputy Commissioner Zero has also mentioned in the report that writ petition number so and so pertaining to the suit land in pending in the Honorable High Court, and ADC actually has been made a party to the case. Further, a civil review petition bearing number 28 has been filed against the order dated 13/11/2000 passed by this court. A copy of the said report has been furnished to the plaintiff. After perusal of the same, Mr. So and so submits that the writ petition pertains to cancellation of LPC of the suit land, which has no bearing upon the present civil suit and the present miscase. Mr. So and so also submits the civil revision petition has been filed, but no stay or suspension order has been passed against the proceeding in miscase number, order dated 13/11/2000 passed by this court. After due consideration, I deem it fit to direct the Deputy Commissioner Zero to record the statement of ADC Yachuli and board members constituted by ADC Yachuli by number so and so dated December 2000, who went to the suit land on 23/12/2019 for damaging assessment. The statement shall be recorded through an executive magistrate competent to take oath, and reports shall be submitted within 15 days. So hereinafter, a proceeding, it was likely to be drawn because the intent of the learned senior judge civil review, it seems, when it has to be recorded an oath, when there is a direction from the court, and if any public or these petitioners, whoever present there, who obstructed the officials, so some proceeding it was supposed to be drawn. Meantime, what happened? Since it was taking time, we have filed a complaint petition. Because one of the relatives of this private restaurant number 5, he went along with those officers, and even he was treated. Then we have filed a complaint petition, and basing on that complaint petition, the statement of all the officers were recorded, wherein, my lord, it is very clear that even the order of the court, that is Civil Judge Senior Division, that was undermined by these petitioners and the villagers. And that is also now pending trial matter. Page 130, my lord. This is the report that is submitted by the EAC Judicial to the Civil Judge Senior Division. Subject statement on oath in respect of miscase number 55/19 TS number so and so. Sir, proposed to the subject and in compliance with your judgment order cited above, the undersigned have been directed to record the statement on oath for the assessment committee duly constituted by the Deputy Commissioner by number so and so, data so and so, 2009, and subsequently reconstituted by the ADC actually, copy and close. The statement on oath by the additional Deputy Commissioner actually and other constituted board members for damage assessment is annexed as flag B, C, D, and E respectively. So next page onwards, type copy is also there. These are the statement on oath of the officers, those who have been to assessment, my lord. Now, my lord. Under such circumstances, my lord, kindly come to page 147, my lord.
147.
147, my lord. Forcefully entered in my garden and damaged. Even this assessment team, the authority, were not allowed to go there and assess. So ultimately, this 147, this letter again I have written to Deputy Commissioner, my lord.
Then
That was, this is on 25 February 2022, my lord, subject for necessary order for assessment of damages of my agri horti garden. Respected madam, with respect, I beg to state that I have a private land measuring so and so square meter at Pulisit near Fanya under Lower Sunset district of Arunachal Pradesh. The said land is bounded by so
So
and
back
so.
to you.
I have,
When they want to assess on the spot, when you have prevented them with the question of claiming of natural justice,
That is, my lord, first
I'm judgment.
instance. That is first instance. And whatever my brother Tama is relying, these are all irrelevant here.
is relevant.
No, to my understanding, my lord. Why it is not relevant?
There's
The
a,
second,
there's a order of
see-
the court, right? They want to assess, they want to go report, assess the damage. You have prevented them.
no, thereafter second attempt should be
You
made.
have taken the law in your hand.
Whatever, that's why they are facing the
So
consequences
if it
in the
is,
form of
if it
trial.
is, if it is, if it is, if the authority, the boards, I mean, the officer, experts are prevented from visiting, despite attempts, not once, they've made an attempt twice. Right? And the repeatedly court is
No, that,
passing an order.
my lord, this is,
Now what else he can do?
no, my lord, my primary concern is, this is a disputed question of fact.
No, it's on,
Whether-
it's on record.
Whatever it is,
It's
they,
on record.
we cannot trust
No, it's on record.
whatever.
The court has recorded
Correct.
the finding.
I,
There's an order of the court, civil court.
for a simple stretch of imagination also, I cannot dispute whatever is falling from my lord. But my simple concern is, my lord, okay, first attempt you could not succeed. But while making the second attempt, how
We
you can do
understand
this?
the administration would not have been so helpless, but then
That is the only thing, my
the
lord.
problem is there's no question of not hearing you. You have not allowed yourself to be heard. You have prevented.
That my lord will decide, because I just, as a court officer, my duty is.
So what is the civil this thing?
That
Civil revision is there.
civil revision is
Civil
also there.
division, is there. Kindly come to page 173, my lord, everything will be clear.
173.
173 is the first order of, in that civil revision petition number 38 of 2023, wherein my brother, he tried his best to stay the money suit. But then ultimately this honorable court was not convinced.
So
Later on, the stay was
Later on, basing on this writ petition,
representation? What representation?
no, 173, my lord.
Huh?
What, my affidavit, 173, page 173.
Yes.
This is the civil revision petition,
Yes.
wherein they have put to challenge the money suit that is pending, money suit number 28/2022.
So what is the order?
Herein, my lord, last time also, your lordship has gone through it. Initially, after discussing all the aspect, my lord, this honorable court was not inclined to grant stay. But then later on, after staying of that assessment report in this writ petition, that money suit it was stayed. That money suit it was stayed.
This assessment is also state.
Stayed. After staying this, first it was attempted. When it was failed, then this writ petition come. When this writ petition succeeded in staying the assessment report, then this money suit it was stayed. That is the
How
case.
can this be? Sir,
My lord will take a call in
be
any
fair,
case.
be fair. Let us be very fair.
My lord, fundamentally, my lord is also aware.
Once it is rejected, unless there's a
Change in circum.
My lord, the civil suit pursuant to this loss assessment certificate, impugn loss assessment report, is
having
another
heard the
thing.
projection,
But
made-
here in,
having heard regard to the projection made by the impugn communication, are hereby state till the next. It is further that there will be no impediment for responsible mechanism in terms of the. How can there be a assessment now? Can there be?
My lord,
Can there be an assessment now?
no, my lord, that
Can you make can they make the assessment now?
assessment, it is not possible, my lord. Therefore, my application 147, why I have said so, my lord, my application, therein, I have stated to the deputy commissioner, my lord. Now, since 3-4 years has already lapsed, so at least basing on that report, charge sheets, as because IO he himself visited the PO, at least some assessment may be done. Basing on that application, deputy commissioner has directed, kindly come to my lord, that page number 147, which I
Your
have mentioned.
application, your application.
Affidavit.
One,
My affidavit.
147.
147.
I knew he will come to this space.
Operative portion 148.
Yes.
Herein I have narrated everything. First attempt, second attempt, it was failed, 147 and 148.
No, that I've seen. This is your application. You said some orders.
No, my lord, basing on this, the deputy commissioner has issued the order to the horticulture officer and agriculture officer to at least make assessment on the basis of charge sheet. That was on my request, my lord. 148 page number, second last paragraph may be kindly seen. Thus, I request you kindly to direct or pass an appropriate order to the expert horticulture officers to assess the loss amounts basing on the record available in the charge sheet. That my emotions, mental and physical attachment with my guardians too was ransacked by the Nilam party, and I beg you to kindly deliver a justice to me. This is after second attempt, one of the order of deputy commissioner, one of the order of the learned civil judge senior division. Therefore, when no option it was left, then deputy commissioner directed these two officers. Factually, this is the case, my lord. And basing on that report, we have filed money suit number 28 of 2022, which is
At the
pending.
first blush, your case appears to be very simple and meritorious.
And therefore, my lord, lordship has rightly said,
Having a merit. After
every
hearing it,
violation, my lord, every violation of
really it was a blush.
every violation of principle of natural justice, my lord, is not a fit case to be entertained under Article 226, my lord.
We'll dispose of that what the civil division is together.
Last time also, it was nearly disposed of, my lord. That's civil division.
Nearly disposed.
Nearly disposed.
In fact, today.
What is the ground in civil division?
Civil division, they are saying on the same allegation of damages, there is a pending criminal trial which is going on. Therefore, there cannot be a money shoot out of same charge sheet.
Parallel
assessment.
proceedings, only parallel proceedings. My lord will take a call because I have done my duty as a court officer. Whatever it falls from my lord, I have to accept. He has to accept. That's all. There are remedies available there.
Lordship, we have just complied with the orders of the deputy commissioner.
Yes. It's not possible to have reassessment. Again, even if it is to be reassessed, you will have to rely on the documents, including charge sheet only.
The person, the officer who visited.
This is the problem. Okay. Heard Mr. Tititara, counsel for the petitioners. And also Mr. Which one? Basar, listed counsel for respondent number 1 and 2. 1, 2, and 3.
4 and 5.
4 and 5, huh? Mr. Swenson. 6. And K. Tama, the husband respondent 6. Hearing concluded, judgment reserved.
My lord, will only mark one thing in this matter. All the incident has taken place after his LPC was cancelled. That kindly take note of that.
Will not enter. It's a matter.
That cancellation, it was interpreted by this honorable court.
Later on, till such time till such time his LPC was not.
No, it's all, it's where only
Loss of
damage. Loss assessment. We're on the loss assessment.
I'm only on that. The
Whether the principle of natural justice, in fact, would apply in such in facts of this matter.
Only
Can be
Under article-
said-
my lord will only consider out of 3 C's. My lord will kindly consider 2 C's. Convince, confused.
Ah.
Which one would be applicable in this case?
Confused?
Third C,
Confused?
convince and confused. The third C, I don't want to reveal.
What is third?
Something I'll fundamentally on 3 things. But
Hello.
great.
Well, this is 4. Yes.
May I please, Your Lordship?
Yes.
Lordship, I tried my level best on my personal level also. But I could not convince my client.
What is the matter?
Your Lordship, this is a PMJSY road which was passing through my land without asking me. They had constructed the road. That is the issue. In Likabale,
Okay.
that one. Lordship had asked me to talk to my client. Yes, I have tried my level best. Since it is their land, it's their thing. I mean, unless I'm willing to give them something else, they were not ready. So therefore, Lordship may hear this matter and be disposed of on merits. Lordship, the issue is very simple. There is a land which is around 83,000 square meters.
Yes.
I mark out the positions also in which the road passes. They have not denied it. Only thing is they have said that there was a meeting and there was a consent and they have simply built the road. That is the issue. They have said, the respondent number 2 has by affidavit said that under PMJSY guidelines, there is no provision for land acquisition. That is one of their grounds. So my lordship has to decide in this case whether or not in terms of rule 5.6 of the PMJSY guidelines, they are entitled to simply take away somebody's land only on the ground that there is no provision for land acquisition. What I have filed and I have filed an affidavit in reply also to this, and I have annexed the PMJSY guidelines. Lordship may see the relevant portion would be at page 52 of my affidavit in reply. I filed yesterday, Lordship. Whether or not Lordship have to decide whether or not saying that
Page
52 of my affidavit in reply.
Not the running.
Lordship, there has been some problem with the registry. So I was asked to repage it. They have said that I'll have to repage it by with page 35, sorry. So
Page 52.
52.
Program guidelines. Program
Yes,
guideline.
yes, yes.
Yes.
Lordship may see, sorry, 5.7, the last paragraph, 5.7,
Hmm.
that the last paragraph of this page.
Hmm.
Has my lordship found?
Yes, yes.
It will be the responsibility of the state government, oblique district panchayat, to ensure that land required, if any, for the purpose, proposed right of way is available for taking up the proposed upgradation road works. A certificate that land is available must accompany the proposal for each work. It must be noted that PMGSY3 does not provide funds, any funds for land acquisition. However, this does not mean that acquisition cannot be done by the state government at its own cost. The state government may also lay down guidelines for voluntary donations, exchanges, or other mechanisms to ensure availability of land. The process of making land available for the roads should subserve the common good and also be just and equitable. The details of the land made available should be reflected in the local land records to avoid disputes immediately upon approval of road work and preferably before commencement of execution of work. Environment and forest clearance will be mandatory before seeking clearance of any PMGSY 3 guidelines. Now, in this case, what happened, Lordship?
It is the PMGSY3.
Lordship, this is in 2019.
Hmm.
So it will come under PMGSY 3. These guidelines is 2019.
Hmm.
In any case, your Lordship must have seen in other cases also.
Hmm.
What the government usually do is they talk to the villagers, they enter into some kind of agreement so that some donation can be given. Usually donation is given. That sort of thing is done. So as when there is no, because PMGSY does not provide funds.
Hmm.
But that is to be done, before the project sanction, as is reflected in 5.7. In this case, what happened is project was sanctioned, road, everything was done. After the
What is the
Lordship?
are the works on?
Yes, Lordship.
There's
They
a
have, yes, they have forcibly,
construction is going on.
yes,
Construction.
they have forcibly constructed or in the middle of my land, and only blacktopping has not been done. Lordship, even for land availability certificate, this has to be done before the project is sanctioned. In this case, what happened is project is sanctioned, everything is done. After they started the project, then only they forcibly build this, taking this meeting into consideration. But Lordship will notice one thing. Time and again, the government affidavit have said that there was a meeting on 24th of August 2023, on which the whole order was passed. But the minutes of the meeting, nothing is enclosed. This is not enclosed because there was no such meeting. Their whole case is based on this, Lordship.
What they are saying?
They are saying that on 24th of August
There was a
2023,
meeting.
there was a meeting. We had said that we will give. So therefore, the impugn order was passed. Impugn order is 28/8/2023. They have not enclosed any minutes of the meeting, any signature from my side. That cannot be, it's impossible because I have not attended such meeting, nor I have given any such consent. Even the foundation of their defense is, Lordship, not proved. Lordship may see the impugn order. They are saying that on the basis of this meeting, Lordship may see page 61. As directed and authorized by the Deputy Commissioner, Lower Siang, a hearing was held on 24/8/2023.
61?
Page 61.
Read petition.
Yes. They are basing their whole case on this. As directed and authorized by the Deputy Commissioner, Lower Siang District, Likabale, a hearing was held on 24/8/2023 at PWD Circuit House, Likabale at 1100 hours regarding land dispute obstruction by landowners, namely Tadorumdo, Kekperumdo, Bomken Kamchen, Tanya Rumdo, and Mamik Kamchen and Kamchen Village Community Land. The meeting hearing was attended by 20 HGBs, GBs of Kanku Circle, landowner, student, union leaders of Kanko Circle, concerned contractor, and the department. After prolonged discussion, it was found that the landowners agreed that the PMGSY road should be constructed. However, they have agreed for construction through Forest Road as per DPR of RWD, stating chances of encroachment by Assam people. The road should be constructed by carving nearby Assam. The majority of statement suggestions given by the people present clarified that boundary issues already under process by the government of Assam and Arunachal Pradesh. Hence, there is no chances of encroachment, and the road should be constructed as per the latest plan, which is under construction. The department authorities stated they have constructed the road through forest, carving the present road into 45-degree, and its distance is more. The junior engineer RWD also stated that such carving is being objected to by higher authorities. The project PMGSY road should be completed as soon as direction of government, else it will be lapsed. He also stated after completion, only new proposal under provision of maintenance are to be prepared and submitted to government for sanction order. The road from PMGSY road is almost complete except this lane in question, which is above 600 meters. The present, as stated, the decision of the hearing is passed as mentioned below. The present road where RWD department has constructed 2 culverts, bridges, and the work in progress except 600 meters objected to by landowners, wherein the community land is not objected to with falls under this 600 meters. As such, the present road should be continued as part by the department as per the latest work in progress. The grievances of the landowners could not be considered, hence it is objected by the higher authorities like Government of Arunachal Pradesh and India as stated above. Besides, construction via forest road is objected to by Assam people, which is longer and also carving in 45-degree. Considering the grievances, the landowners of the concerned, considering the grievances of the landowners, the concerned contractor Sidoi Tarak is to erect barbed wire fencing about 600 meters beside the present straight road. So in terms of this order, that road was forcibly constructed and barbed wire was given on both sides. Now, Lordship may see their affidavit in opposition. The respondent number 2. Time and again, Lordship may see page 24, paragraph 8. Respondent number 2's affidavit, Lordship.
Para 8.
Yes. With regard to averment made in para 9, the answering respondent partly admit and partly deny as follows: that the deponent admitted that the meeting dated 24/8/2000, but denied individual landowner those names. This have raised objection. It is on their mutual consent that the construction of road as per new plan was stated. Thereby, the executing agency has constructed 2 numbers of culvert, including formation as per new plan. Further, as of now, the petitioner are obstructing the construction of road at her land in spite of consenting to a meeting to 24/8/2023. They are saying there was a consent on 24/8/2023. Now this meeting of 24/8/2023, even the minutes are conspicuously absent, Lordship. If they're basing their case on this, saying that this impugned order was passed on this, what is preventing them from bringing this on record? And I'm saying it is impossible to bring on record because there was no such consent, Lordship. Now, Lordship, they have also not denied what I have stated in paragraph 10. In paragraph 10, I have stated exactly at what point the land is, at what point my area is, at what point the earlier road construction is, and at what point they have encroached upon my land. That they have not denied. They have also not denied my ownership. That is in paragraph 12 also.
There cannot be any denial because
Yes.
it's a fact that it's your land.
Yes.
And
Now, Lordship.
road is being constructed over your land.
Yes.
Problem is how can you object it? And you are saying that and even if doesn't provide any compensation.
Yes. It's not that they don't provide. Lordship has.
It may be a reasonable point, but then so far as the diversion.
Yes.
To divert it from other side, it's
Yeah.
not possible. It cannot be. that claim cannot be made.
Lordship, it's up to them to do whatever they want.
Yes.
But Lordship,
No, if
Although-
everyone is there, that's why other day also I think I said
yes,
it has to pass through someone.
I'm just
someone,
Lordship.
anyone, anyone, it has to pass through somebody's land.
Yes, Lordship. Yes, I agree
Cannot
that
be through
Lordship.
you and it
Yes.
be- if it is not your land,
Lordship.
it has to pass through some other's land.
Lordship.
The person will again object.
Yes, my
And that
submission
kind
is
of,
Lordship.
I think,
My submission is Lordship. As my Lordship has seen, the guidelines 5.7.
yes.
What the guideline says is there is no fund provision.
Hmm.
That does not mean the state government cannot acquire the land. That does not mean that they cannot come to some negotiation.
Yes.
That they could do. Now, Lordship, my right under Article 300A, although this is not a fundamental, it is well recognized that the state has under the power of eminent domain, they can take away my land. Of course they can. But Lordship, there has to be not without any authority of law, not without any process. Saying that there is no provision for land, no fund for land acquisition does not automatically mean that my land can be taken away forcibly. Even the guidelines recognizes that. That is why the guidelines has made a roundabout way of doing this thing, Lordship, as per point number 5.7. So, Lordship, I am relying on one Supreme Court judgment in this. Here, Lordship, 2029 SCC 356.
29.
2020 volume 9, 356. Paragraph 96 onwards. Here also what happened, of course, the factually it is a bit different. Here what happened is, while building the municipal roads, one of the appellant's land was carved out and entered into the records as the municipal land. That is how the case came to be. There was also a submission that since it is a public interest, therefore this the land should be given. Under such circumstances, what the Supreme Court has said that under paragraph 96, 97, 104, 102 would be relevant, Lordship. The right to property, paragraph 96, Lordship. The right to property may not be a fundamental right any longer, but it is still a constitutional right under Article 300A. A human right as observed by this court in Bimla Ben Ajit Bhai Patel versus Vatsalan Ashok Bhai Patel. In view of the mandate of Article 300A of the Constitution, no person is to be deprived of his property save by authority of law. The appellant trust cannot be deprived of its property save in accordance with law. 97, Article 300A of the Constitution embodies the doctrine of eminent domain, which comprises two parts: the possession of property in public interest, the payment of reasonable compensation, as held by this court in a plethora of decisions, including State of Bihar versus Project Ucha Vidya Shiksha Sangh, Jilubhai Nanabhai Kanchar versus State of Gujarat, Vishambar Dayal Chandra Mohan versus State of UP. The state possesses the power to take or control the property of the owner for the benefit of the public. When, however, a state so acts, it is obliged to compensate the injury by making a compensation as held by this court in Girnar Traders versus State of Maharashtra. Then, Lordship, paragraph 102. In appropriate cases, in order to prevent injustice to parties, the court may itself pass an order to give direction which the state government or the public authorities should have passed. Had it properly and lawfully exercised its discretion. In Director of Settlements AP versus MR Apparao, Patnaik J observed, one of the conditions for exercising power under 226 for issuance of mandamus is that the court must come to a conclusion that an aggrieved person has a legal right which entitles him to any of the rights, and such right has to be infringed. In other words, existence of a legal right of a citizen and performance of a corresponding legal duty by the state or public authority could be enforced by issuance of a writ of mandamus. Lordship, I'll skip this, Lordship. Paragraph 104, Lordship. The High Court is not deprived of its jurisdiction to entertain a petition under Article 226 merely because in considering the petition's right to relief, questions of fact may fall to be determined. In petition on Article 226, the High Court has a jurisdiction to try both issues of fact and law. This is on the jurisdiction, Lordship. So basically, Lordship, what I'm trying to say is they cannot simply give a total, Lordship, miss to the whatever provisions are there for taking away the land. This is not the right procedure. This is even an illegal procedure. They have relied on some non-existent document saying that I have consented, we have consented, which is not even true. This is, in my humble submission, an example of total high-handedness. This cannot be allowed by this honorable court. They have not approached me even.
My lord, in prayer person, there is no any prayer for compensation. The prayer is only to set aside the order dated 28 August 2020 passed by the ADC. And to stop constructions to pass through his roads, plot. That is only to prayer made in the, so question of compensation is not arising in this petition. And regarding construction of road is already constructed through that plot. Now even vehicles are passing through that plot, except because of stay order, other remaining work could not executed in 600 meters portion out of 30 kilometers, 600 because of this case. So this main challenge is the order passed by the ADC. Inter student organization of that area, GBs, interpublic, they want the road to be passed through that portion. And they have sought for, in lieu of passing that road construction, the DC says clearly, the ADC has clearly stated a pension can be erected for him, both side the roads. That's what's condition number
4-1.
Yeah, 3 is written. Considering grievances of the landowners, the concerned contractor, such as such, is to erect barbed wire about 600 meters beside present state of roads. The side of the, if the road pass through that portion, if really the petitioners have the vast area of land, they will also benefited by that road. So it's a question of 600 meters by 3 or 4 meters.
What she said is saying is that they have not consented.
Had
They
they
have
not
given their consent.
if they don't consent, the question of construction in early stage does not arise. Since in the beginning, what I am told is they have consented. Behind the scene, there many things remains that we cannot say.
What about this, the page 52 affidavit?
Page 50.
Guideline, affidavit.
No, there is a guideline, my lord, that there is a guideline, state government can, there is no dispute, state government can give compensation. But PMGS, there are so many projects, thousands of projects. If it's started compensation, state government exchequer will be empty. They have.
Yes, that's what I want to say. State government is not in the position to pay compensation to the PMJ.
Just because it will burden.
Once it is given to anyone, what's it?
Madam, if it's just because it will have a burden on the state exchequer, you cannot defraud the citizen.
Say lots of starting if no one is given or only 600 if somehow.
If nobody one is claiming, it doesn't matter if it's okay. They are generous people.
No, all will come, Lord. All will come. That,
Let them come.
this will be the start value.
You have your own guideline. You work under within the four corners of that guideline. And you just pick up some
No, my lord,
guidelines and you just ignore.
because of
What I'm
that,
saying is, I understand it will have
yeah.
a really big, huge impact on the
Yes.
state exchequer. I understand, but then
So
certain these things are provided to you as as a guideline. Why don't you follow this also?
So normally before construction, it's the villagers who used to give the lands for construction. Is because of them only construction can, unless they give donation. In every case, it's donation. The state government can also they use it.
If they can provide any document saying that I have donated,
In
I
other
will raise
cases
my
also.
case. Before the project, if they can submit any documents saying that I have donated, I will raise my case.
Okay, I'll pass down. Heard
Alright.
Miss and learned counsel for the petitioners. And also heard Mr. Which one? You? Which one?
I am for
You are two and three.
one,
G Tarak Learned
Three.
Standing Council RWD for
1 and 3.
1 and 3
Yes.
and MSG at Learned Edition City Government. Oh,
Not only one,
Two.
two.
Baki two.
is 1 and 3. How many respondents? Three
Others
only.
are private respondents.
They've served, they've been served,
Yes, we have filed an affidavit also to that effect.
non appears. Non-represented for respondent number.
Four, 5, 6, and 7.
4 to 7. 4, 5, 6, 7, and 7. Hearing concludes, order to follow.
No.
Only day. That was only day. Okay, complete the same. Yes.
So notice was issued on 27/1/2025. We have taken steps.
Hmm.
Somebody's name is also shown.
Respondent number 1. How many respondents?
Two minor, same minor. One is the corporation, two is the head of the office.
Oh, they filled the bucket now.
It appears, so somebody's name is also written.
What is to be done? What to do?
No, they have not filed their affidavit. Let it be after vacation.
Okay, heard Mr. Deepang learned counsel to the petitioner. It is indicated that, no, it is seen that but the response have and are represented by the council.
Local council.
Harel Tungon. Please have a non-appears. Non-appears for the respondents today. List the matter after 3 weeks. In the meantime,
Interim order.
what is the affidavit is there?
Madam?
No, it's
No, madam.
proof of notice service. In the meantime, the respondents may file their affidavit. Interim order pass always.
Okay.
Number 7.
Yes, sir.
This is a service matter. I have already served a copy to them and
Yes. Which for the respondent? Hmm? State. So. You file an affidavit?
yet to file.
Or Mr.
Or Deuri.
Or the land counsel for the petitioner? On the prayer of Mr. Ensora, appearing on behalf of Mr. M. Katulana DSA, for the 3 weeks time is granted to file affidavit. 3 weeks. Yes.
No, madam, they have filed their affidavit, madam. As per their affidavit, this matter can be disposed of, madam.
How?
This matter, they are saying that the cadre review, the process has been started. madam.
Started.
Yes, madam. Since 2022, yeah, madam. Therefore, this can be disposed of with a specific direction to complete the process within a specific period of time.
Or Mr. Can be done.
My lord,
Can we dispose it of?
Yes,
no, my lord.
Can we dispose it of the
No, my
matter?
lord. No, my lord.
Why?
My lord, I have an objection. But unless the, my lord, that process is, my lord, completed, at this stage, my lord, the considering the case of the petitioner is very difficult, my lord. It's because in paragraph, my
No,
lord,
we'll say that since you have started the review of the, what do you call it?
Cadre review.
You
Cadre review.
started the process of Cadre review
my lord,
complete.
the recruitment process is, my lord, after that, my lord, the recruitment process is, my lord, under.
No, why not passing, specific order saying that he should be promoted, recruited?
Yes, madam.
It-
Only to finalize the cadre review, madam.
Yes.
Cadre review will be only possible when, my lord, the recruitment process is over, my lord.
It's
Recruitment
up
rules
to-
is over.
Up to how long it will take?
Yes.
My lord, it is also, it involves, my lord, the several.
We'll say you complete your Cadre review.
And my lord,
process.
another thing is, same matter, same issues
Hmm.
raised by the same petitioner, my lord, is pending before the Honorable High Court of Delhi, my lord.
Same.
Same, my lord.
I think not, my lord.
So therefore, my
I
lord,
have no idea, my lord.
therefore, my lord.
By the same petitioner.
Same petitioner, my lord.
How can you do that?
Yes,
And
my lord.
I have no idea, my lord.
And the other
Take
similar-
instruction. We'll take it up tomorrow.
Same cadre review, same.
Same cadre and
By the same petitioner.
same petitioner, my lord.
Let us see. Do you have the,
My lord, I'm sorry, my lord.
If
I'm
they
not-
have any order, my lord. I have not been.
where is your affidavit?
My lord, in my affidavit, my lord, categorically that statement is not taken.
Hmm.
But my lord, if lordship perused, my lord, the paragraph,
Page 40th K, from K, they said they started the process since 22, my lord, 2022. Last cadre review was done on 2015, my lord. Every after 5 years, they have to carry out the cadre review.
my lord, just for,
Prayer number 2 we are not.
I will not press that, my lord.
Just
Since
for-
you have, where it is,
my lord, just for a moment, my lord, may I
where
take
you
your-
have said
my
that
lord, it
the
is-
Cadre review has started.
Page 40th, my lord,
48.
of their affidavit, K, my lord.
Hmm.
So, para K, my lord.
my lord, I'm relying page number 64, my lord.
Just wait. What is the number K
Page 40th,
for ongoing Cadre review?
that.
There's
my-
page 49.
49, okay. Might be in my 40th. That's for-
Subpara 4.
Yes, my lord.
Is it subpara?
Subpara.
Page number 49 also, my lord, we have stated. And my
Ah.
lord, page number
Preliminary
50.
subject, submission and objection. Para 8 of K, right?
K, huh?
Yes.
Page 49.
That for the ongoing cadre review, a board of office, chaired by chief engineer and civil level officer of the bridge, civil cadre was constituted at headquarters of GDBR. Accordingly, the draft cadre review proposal was prepared by the board of office. The draft board proceedings were also circulated to the members of bridge cadre for moments for ensuring complete transparency. Draft cadre review proposal was thereafter submitted to so and so on October 22, my lord. Duly incorporating all the inputs, a high-level committee under the chairmanship of so and so Ministry of Defense has been constituted by the ministry by order dated so and so 2023. as the level officer of the bridge civil cadre is also the members of the committee constituted by the meeting of the committee was held on 9/4/2025 under the chairmanship of Soson. Discussion the proposed cadre review of the border road engineering service. Various issues pertaining to the bridge cadre review were deliberated during the meeting. The committee recommended that there is a requirement to examine and analyze various road construction organizations like so and so, which are executing works and EPC mode. Accordingly, chaired by the chief engineering level officer of the bridge cadre has been constituted for the same. The board is under the process and report will be submitted during next meeting of the committee for consideration by the members.
Is only for
Yes,
cadre review.
yes, ma'am.
You have already undertaken.
Yes, my lord. It is also not yet, my lord, the if lordship peruse the, my lord, the another, my lord, the
Once you complete the record, the cadre review, consequences will follow.
Yes.
Whatever benefits it can be. We're not passing that, it should be provided.
Yes,
my lord.
When can you complete?
My lord, this is also not, my lord,
We'll say
Yes.
within a reasonable time,
my lord, page number, my lord, 54, my lord,
54.
just first paragraph, my lord.
Hmm.
50, my lord,
Yes,
54.
yes.
The committee recommended that there is a requirement for the examine and the analysis the various road or construction organizations like NHAI and
The
the
same
NS.
you are repeating is
My lord.
level of officers cadre has been considered for this. The board is under process report will be submitted during next meeting for consider member. Therefore, the process is under active administrative consider. And the contention in the form of present it was denied and liable to be dismissed at instead. Huh?
Yes, ma'am.
We're not providing him to give the service benefits, whatever. He also said that only for.
My lord.
We'll just observe that in view of this, your statement, your stand, you complete the cadre review within a reasonable time.
Yes, my lord. That is what.
We'll not fix it.
Without my lord making the, my lord, giving the outer
It's a reasonable time.
I have since 2022.
It's all right.
Otherwise, the last
Okay,
cadre review was
heard
done-
Mr. Cadre Learned Counsel for the petitioner. One petitioner
What?
Yes, one petition.
by filing this writ petition. The petitioner has essentially prayed for a direction to the responding authorities to carry out the cadre review of what is this BRES?
Border Road Engineering Service.
Border Road Engineering Service within bracket civil bracket clause. An organized group A service of the General Reserve Engineer Force as per the guidelines of Department of Personnel and Training of the central government. By following the model cadre structure with retrospective effect within a short possible time. Next paragraph. The petitioner is working as superintending engineer within bracket civil bracket clause oblique director estimating project Brahmank at Pasigat, in the state of Pasigat in the state of Arunachal Pradesh. Mr. Mr. Claims to be aggrieved of the inaction on the part of the responding authorities to carry out mandatory cadre review after an interval of every 5 years, as per the letter of Department of Personnel and Training of the Government of India, dated 06/05/1972. Please. It is contended that it is the contention of the petitioners that after even after expiry of 9 years, no cadre review has been undertaken. No cadre review of border road engineering services within bracket civil has been undertaken, as the second cadre review of the said services was held in the year 2015. Mr. Next paragraph. Mr. Cadre, learned counsel for the petitioner, submits that the petitioner has was duly selected by the Union Public Service Commission and joined the service as Assistant Executive Engineer on 24/03/1993, and now holding the post of Superintending Engineer. Mr. He submits that had the cadre review been carried out at regular interval of every 5 years, as required to be done by the, as required to be done under the provisions of rules, the petitioner would have been promoted to higher pay scale of chief engineer, as the petitioner has been provided non-functional upgradation equivalent to the pay scale of chief engineer from 01/01/2022 by the order dated 11/05/2024. Although he is entitled to be provided from 2013. Mr. Curry, the council having submitted above. No, please, therefore, the respondents may be directed to complete the cadre review process. Mr. Next paragraph. Mr. Cadre, learned counsel, having submitted above, further submits that however, submits that since the respondent authorities appears to have initiated the cadre review process as per the step taken in their affidavit in opposition. The process which has already been initiated may be directed to be completed within a time frame. Mr. What is your strength?
Well, my strength is,
You already started.
we have already started, my lord, only the pendency is before the different ministries, my lord. May I take your lordships to the affidavit file,
Ministry, you are representing a ministry.
my lord?
So,
My lord, just for a moment, may I take your lordships to the page number 48, ground G, my lord, page number 48, my lord. That all the posts of BRO are sanctioned by a high-level committee of the ministers known as CCS, in which Prime Minister, Defense Minister, my lord, the Minister, Home Minister, Finance Minister, and Minister of External Affairs are members, man. By order number so and so, so and so. The post of army, my lord, our contention is it involves my lord, the various levels of ministries. So therefore, my lord, it takes time. So therefore, my lord, once everything is completed, my lord, his case will be considered whether giving the promotion or that benefit, service benefit. Is
so
one
basically, you are not saying that though you have already initiated because of the involvement of so many committees and ministers,
my lord,
ministries,
ministry.
within a time frame, it cannot be
My
done
lord,
within
my
a
lord.
time frame.
My lord, the reasonable
It takes
time
its own time.
in accordance with law, man.
And there is a cadre review committee. That's committee has to.
Committee has to be
Okay,
approved by the
Mr.
different ministers.
M. Kato London DSGI. If you are representing the respondents, submits that all the posts of BRO, Border Road Organization, are sanctioned by a high-level committee of ministers known as CCS, in which the Honorable Prime Minister, Honorable Defense Minister, Honorable Home Minister, Finance Minister, and Minister for External Affairs are members. Mr. The post of Army and GREF, General Reserve Engineering Force. General Reserve Engineering Force.
My lord, yes.
General.
General.
It's a general.
Yes, sir. General
General
Reserve
Reserve
Engineering
Engineering
Force.
Force officers. And their distribution are clearly defined. The post with the combined strength of both Army and General Engineering Force are allotted based on Manning Policy, MANN, of Government of India, by the orders stated. And orders in 1981, 1990, 1991, 2010. Mr. He submits that although the cadre review has already been initiated and is under active consideration, it would not be in view of the involvement of various ministries
My lord.
and the committees, members of the committees, members of the committee, it would not be possible to complete the process within a given time frame.
My lord.
However, he submits that the the authorities would definitely, certainly undertake the process within a reasonable time in accordance with the relevant rules.
Expeditiously as possible.
List of next page. Having considered the submissions of learned counsel for the parties and also considering and the extent of the responding authorities. No, before that, the respondents, sorry. Who is this? Who has filed this affidavit?
Madam, respondent number.
No, the responding authorities. Wait.
Respondent number 4, madam.
You're representing all.
Yes, ma'am.
On behalf of
Yes.
all. The respondents have filed their affidavit. Where it is the making where it is stated at page 49, page 49 of the affidavit. It's subparagraph K, stating that for the ongoing Cadre review, a board of officers under the chairmanship of Chief Engineer within civil level officer of Border Road Engineering Services, Civil Cadre, was constituted at headquarters DGB. You put this, Then you said, having considered the submissions of the land council for the parties, and also and the state of the responding authorities, as noted above. I'm of the considered view that no no issue remains to be adjudicated upon as the responding authority has already initiated the Cadre review of the Border Road Engineering Services
Yes.
within bracket civil
Right.
bracket close, and is under active consideration list of. Accordingly, the writ petition is disposed of with a direction to the responding authorities to complete the Cadre review process in view of the fact that the Cadre review has not been as expeditiously as the Cadre review appears to have not been done since 2015
Cadre review of the petition, Cadre review
of
the Cadre review
of
the
border road engineering
My lord.
services within brackets civil.
In respect of
It's-
petitioner, my lord, in accordance with law, my lord.
Cadre review, it's not only for one, I think.
Yes, ma'am.
It's for all.
Exactly, madam. As I'm informed, madam, altogether 16 or 17 cadres are
Ah.
waiting for under consideration.
There is, my lord, memorandum is also there to carry out together every year, so every
Needless,
5 years.
needless to observe that next para. The on the completion of Cadre review, the petitioner maybe would be entitled for any benefits that may be permissible under the law.
Ma'am.
We'll just observe like
Yes, ma'am.
read petition disposal.
Obviously.
Development.
Yes,
No, I'm entering appearance on the private respondent today.
okay.
Actually, I got confused, my lord. I was under the impression that this was withdrawn.
Okay.
Earlier it was withdrawn in any case. Affidavits were ready in that case was filed. So I will not take much time. By next week, I can file the affidavit.
Heard Mr. Peter Learned Counsel to the petitioner and Mr. Jitara, Learned Standing Counsel for Learned Standing for Rolling Works Department. For respondent number 1, 2, 3, 4, 5, 6 and 7.
I am
And
for
6,
seven.
6. Okay.
7.
1, 2, 3, 4 and 5. You're for 7.
7.
Who is for 6?
I'm the beneficiary 7.
Okay. Don't appear.
We have already taken step Dusty also. So,
That's it.
yes.
Okay.
It's a
None
record.
appears for the petition. The respondent number 6, dispatch service of notice listed. And next, Mr. Deepang Learned Counsel enters appearance on behalf of respondent number 7 and prays for 2 weeks time to file affidavit. 2 weeks or 1 week.
1 week.
So by next week means
Yes, on
automatically
fourth-
it will go.
Yeah, on 4th, my lord.
4th, so immediately can we? 4th is what? Second last day.
Yes.
Yes.
Last time, my lord,
What is there? What is there?
Hardly take 10 minutes, my lord.
Okay,
Otherwise, nothing.
every learned lawyer says so. You may take 10 minutes. This code takes may 15 days.
Let it be after the break, man.
Anyway, we'll say
After it.
we'll say 10 days.
Yes.
Let us see.
Here, madam, for the respondent, madam.
Yes. Where is the matter, sir? You have not filed the affidavit.
No, madam. We were not furnished with extra copies also.
Huh?
We were not furnished with extra copies.
You are for?
I'm for respondent number 2, 3, and 2
Okay.
and 3.
Yes.
Yes, your lord,
Mr. Manta, you furnish extra copies to your senior colleague, Mr. Tafo.
your lordship, that step has been taken, but then I'm unaware as to why that has not been received. We have immediately
Why
taken the
extra
steps.
copy? Don't you have the writ petition?
No, no, I have the.
We will-
You have the,
Yes.
you have 1 copy. Why you need extra copies?
Madam, we have to have 2 copies. We have to serve the 1 copy.
You are what?
2 and 3.
Cooperative apex
Yes.
based. Still 4.
Your lordship,
Still
your
4.
lordship, since your lordship,
No,
I am
this is
under
not that
suspension.
poor, madam.
Ah,
Your lordship, I am under suspension since from the past 19 years, your lordship. My suspension has not been revoked. No departmental action has been taken.
Okay.
And then no
Yes.
subsistence allowance has been paid.
What happened? How can this be allowed? 19 years under suspension.
19 years, Your Lordship. This is an open and shut case, Your Lordship. So requiring an extra copy would not be justified at this stage since he is having
Then
the
when did you
copy
file
of the
this?
writ petition.
When did you file this writ petition? 2025.
Yes, this petition
Were
has been
you-
filed on 26th of March 2025, Your Lordship.
Where you were for last 19 years?
Your Lordship, I was expecting that I would be served with a copy of
For
any
19 years.
department. I was here only. I'm here only. I'm at Namsai only. My place of posting is at Namsai only. So during the period of my suspension, I have been placed in Namsai only. No subsistence allowance, no reinstatement, nothing, Your Lordship. This is a subtle law.
Subsistence allowance,
Need to
Malad,
refer to the
that
judgment,
is
Your Lordship.
subject to
This is
furnishing of non-employment certificate. That the instruction which I got.
Your Lordship, my
said
suspension
that-
has got
That
not
non-employment certificate was not furnished to the bank. That's why subsistence allowance was.
But this is too much, 19 years. No
19 years,
proceeding,
Your Lordship.
you have not initiated any proceedings.
Some proceeding.
You file
happened.
affidavit, 10 days.
Yes.
But when did you wake up from the slumber? 2025 only.
Yes, Your Lordship, we filed this petition on 26th of March 25, Your Lordship.
Rib and winkle. Anyway.
Yes.
2 weeks. Just give them 2 weeks. Let them file their appeal. Right?
Your Lordship, let there be a specific date, Your Lordship.
Hmm.
I pray for a specific date, Your Lordship.
And Mr. C.T. Mantau.
C.W. Mantau, Your Lordship.
C.W. Mantau, learned counsel for the petitioner. Mr. Peter, learned counsel, learned standing counsel, FX Bank. Fresh for and is granted further 2 weeks time to file affidavit. If it 2 weeks, we'll see after.
Obliged.
Blessed.
You choose a date.
After 2 weeks, Your Lordship, any date on a specific date may be given. After 2 weeks.
22nd of July.
All right.
Let
Your
it be on 28, Malad.
20.
28.
28. 28.
It's all right, Your
Uh,
All right.
yes. What is it, IAs?
Your Lordship, for alteration and modification of the interim order, Your Lordship.
Hmm.
On the last occasion, Your Lordship, petitioner, this respondent sought time for filing objection, Your Lordship. I have not received any objection, Your Lordship.
Huh?
Objection copy I have not received.
This morning we have filed the objection.
This morning.
Yes, Your
What is your objection? What is your objection?
Your Honor, according to this, it has been alleged that petitioner has been continually encroaching upon the government land.
Hmm.
However, Your Honor, that the petitioner denied the allegation made by the state respondent.
Hmm.
There was no such any activity has been conducted on the part of respondent. In the Your Honor, that on 26 March of 2024, that group of people, they came to the house of petitioner. Thereby they have destroyed the house of the petitioner. That destroyed portion was being, the renovation activities was being carried out, Your Honor. No further encroachment was being done by the petitioner, Your Honor. In that regard, Your Honor, that the petitioner, the wife of the petitioner has lodged one FIR against the person who have destroyed the house of the petitioner, Your Honor.
Yes, what is your right?
Yes, Your Honor.
It has been, it's a notified government land, donated by the some other people.
Your Honor,
Villagers were Bamin and Bila.
in this
Just
plot,
because you have occupied, how you,
this plot of land, Your Honor, I have been staying since from 1980s. When this land was.
are you claiming that it's your private land?
Yes, Your Honor.
Just occupation will not, it can be, you have been, might have illegally occupied it.
Before this land was donated to the state respondent,
Hmm.
my father was already there in occupation of this land.
You consider if he can be allotted as per the government policy,
Yes, Your Honor.
since he has already constructed this house.
But that area was donated for establishing lordship, district administration for that purpose.
Yeah,
Lordship. And there are
now
other
he's under
encroachers.
Occupation of 1,000 square meter only.
Yes,
Yes,
but there are other people also who are encroaching the area, your lordship, and we have notice to those people.
We are not
And they are-
interfering with the order of the deputy commissioner and that. But
Yes,
then we'll say.
and he has not challenged that order also, your lordship. In the prayer, your lordship, they have not challenged the order of the estate officer and the DC also.
Yes, let us see. But this court has
Yes, that,
said so.
your lordship may kindly see the prayer, your lordship. Under the premise.
We cannot grant you this prayer.
The land has been
The
donated.
basis is only your occupation since to 1980.
Since from my father.
Since 1980?
Yes, Your Honor.
By your father?
Yes.
How can you declare that you have the right to occupy over the land? How can we declare that?
Your Honor, this honorable court have a jurisdiction to declare that land in favor of the petitioner.
Who?
By this honorable court.
Who has declared?
No, it was the prayer made by the petitioner in the.
But is your prayer only?
Yes, Your Honor.
This is your prayer only?
Yes, Your Honor. Petitioner has made prayer that to declare that.
We'll vacate the order. If not, otherwise we'll dismiss your writ petition.
Lordship, I'm praying for dismissal, your lordship.
That we'll dismiss, but we will provide you to exercise your discretion to consider his case for.
But after
allotment
donation.
of a particular, if it's permissible under your policy.
Yes, Your Honor.
But after
Consider it.
donation, your lordship, notification has been issued, your lordship. He knows that. the land
If you
is the
cannot, allot, it's up to you. But then you have the policy of allotment of the government land. Considering that your declaration, although he may not have right as such, but then citizen of the country.
He cannot
consider
seek
it.
lordship adverse possession in the form of deed, your
No,
lordship.
it's not an adverse question of adverse position.
Your Honor, that petitioner entire in this world have no any land except this, Your Honor.
We'll
And-
provide them to consider your case, that's all.
Yes, Your Honor.
Nothing else. We're not interfering with, rather, we're dismissing your claim, relief. Relief cannot be granted as claimed by you, but then we'll provide. What do you say?
Your Honor, that in the state government, that every land that the public has right to get allotted in that government land also.
Lordship,
But you have not prayed for also that you are not challenging the decision of the deputy commissioner. State
State
Your
authority.
Honor, in prayer that have not been put to challenge. However, in petition that the order of the state officer and deputy commissioner has been put to challenge in this petition, Your Honor.
Prayer you have not, you forgot to mention
Yes, Your Honor.
in the prayer. Heard Mr.
Ebodo.
Ebodo,
Yes, Your
then counsel for the petitioner. Claiming to be in possession of 1,000 square meter on which he has constructed his house and purportedly since 1980. This writ petition has been is instituted, praying for a declaration that the petitioner is eligible to be eligible for claiming right over his occupied land on the principle of adverse possession. Please. The brief facts of the case is that the petitioner, the father of the petitioner, has occupied a plot of land What is the plot? Initially you have said how many area measuring?
Earlier, Your Honor, the petitioner had 10,000 to 12,000 square meter. But however, now only he is in possession of 1,000 square meter.
12,000.
Earlier,
12,000
but now
square
only in
meters
1,000 square meter.
by his father. In 1980, by clearing dense jungle and using the clearing dense jungle and used for agriculture and horticulture purposes. At what this area called? Which particular area? Bilad Bamin.
Yes, Your Honor.
Bamin Bilad village.
Bamin Bilad Circle, CO headquarters.
Near Bamin Bilad area, Pasigat, in the district of East Siam. Mr. Thereafter, however, the petitioner is now occupying only 1,000 square meters on which he has constructed his residential house and staying with his family. Mr. Counsel by the petitioner submits that although no specific prayer has been made, the petitioner is aggrieved by the order of the. What is that order?
Order dated 25/5/2020.
Notice and thing. Page.
34, Lordship.
34. This is by the Deputy Commissioner.
34 and 36.
Where's the eviction notice?
36 is passed by the
Okay.
DC and 34 is by the estate officer.
Order dated 25/05/2022 and passed by the state officer whereby the petitioner has been directed to vacate the land within 1 month from the, within 1 month. And also the order dated 14/9,
14/9.
14/9/2022. Passed by the Deputy Commissioner, whereby the appeal under Section 12 of Arunachal Pradesh Public Premises Eviction of Unauthorized Occupants Act 2003 has been dismissed, dismissed and dismissed by upholding the order of state officer. Mr. He submits that in view of long period of possession over the land, and by applying the principle of adverse possession, the petitioner cannot be said to be an unauthorized occupant and is entitled to be to claim over the land. MS Arbasar, Land Council to the Land State Council, submits that. When was the declaration? You filed the affidavit.
Yes, Your Lordship.
Where is your declaration? No, notification.
Notification. It's at page 15, Your Lordship.
15 of your petition.
Yes, my
Affidavit.
affidavit.
Where it says?
Page 15, final notification.
Where? Page 15.
Page 15.
From where you should read it?
Where is the land measuring?
Where is? Huh?
Yes, Your Lordship. Page 15 of my affidavit in opposition.
This is by whom? Okay. Yes, this is notification.
Yes.
Ah.
Where is the land measuring 180 acres, mere fully described in the schedule?
Submits that the land measuring about 180 acres at Bilad Bamin, Isiang district. Has been notified by the state for the purpose of establishment of circle headquarters at Bilad Bamin, Pasigar, on the which has been donated, voluntarily donated by the public of the Bilad Bamin village. Please stop.
Deed of agreement is also there, Lordship. Page 21, 19/1/1990.
It's okay, we'll not go into that. on 22nd, 2002, right?
Yes.
22/02/2002. The petitioner is not a resident of Bilad Bamin village. Please stop. It is not from Bilad Bamin village. And he is a mere encroacher over the land. Please stop. Since the land has already been notified for the establishment of circle headquarters, the claim of possession and occupation over the plot of land in the said area, in the area, in the said area. It is nothing but a mere encroachment, and as such the petitioner is an unauthorized occupant. Mr. Therefore, the petitioner has no right to claim over the plot of land as is a unauthorized occupants. You have not applied for allotment also.
No. Your Honor, there is no process for the allotment process is not there in village.
That is not true, Your Lordship. He has not applied, Your Lordship.
Several
No,
times we
the
have submitted.
donation of the donation, it's a government land now. If
Yes.
it's a heads up,
Several times we have applied, but the application has not been accepted by the.
hard to believe. Be fair,
Yes, Your Honor.
sir. Be fair.
That the
With the
application,
question of not accepting it.
Your Honor, that application that we have submitted before the Deputy Commissioner also.
Next paragraph. Consider the submissions of land counsel for the parties and also peruse the materials available on record. Next paragraph. Admittedly, the plot of land under the occupation of the petitioner is a part of the land measuring 180 acres of which has been notified for establishment of circle headquarters at Bilad Bamin, Fasigar, in the district of East Siang. Mr. The land has been continue on the voluntary donation of the public of the Bilad Bamin village. Mr. It is also admitted position that the petitioner is not an original inhabitant of the Bilad Bamin village. Rather appears to be rather an occupant over the plot of land. Over the plot of over the portion of land which has already been notified by the government for circle head established for circle headquarters. Mr. Next paper. it is noticed that it is noted that the claim of the petitioner appears to be, and then the basis of the claim over the plot of land is to the effect that the father, his father has occupied the land since in the year 1980, which was a community land. At the relevant point of time, the people were allowed to settle on the community land, and he has no idea, he has no knowledge when the community land was donated to the government. Mr. Does the claim appears to be? The claim, does the claim for declaration to eligible to the claim for the relief to declare the petitioner to have a right of claim over the plot of land. And the principle on the principle of adverse possession, it cannot be accepted, as no, there is no documents to show that the petitioner and the father of his father has occupied the land as the original as the owner of the land. Rather, admittedly, the land belongs to the people of the Bilad Babin village, who has already donated the land for establishment of circle headquarters. Mr. It is also said that the donation of the land by the people of Bilad Babin village has donated the land by a deed of agreement made in 1990. Thereafter, the state government has issued a final notification on 22/02/2002 by following the due process of law. Mr. As the petitioner has unauthorizedly occupied the government land, which has been declared for establishment of administrative circle headquarters in the interest of public, for the interest of public, is claim of possession is claim for is a claim of possession since many years as also not acceptable. Mr. having considered above, I'm of the considered view that the impugn order, eviction order as well as the appellate ordered by the state officer East Siang District, state officer and the deputy commissioner East Siang District. Cannot be said to be issued and passed contrary to the provisions of the law. No, as it is clearly established that the portion of the land under occupation of the petitioner is a government land legally notified for establishment of circle headquarters. In view of the above, no relief can be granted to the petitioner.
Your Honor,
Please, does
prior to the notification issued by the state, I was already in possession of 18 years till that.
accordingly the writ petition stands dismissed. Next, no relief can be according to the writ petition. However, having considered that the petitioner has already constructed a house over the land and is staying with his family, the respondent authorities may consider the case of the case of the petitioner for allotment as may be permissible under the relevant policy and the law of the state, right? You may consider. You prevail over them, request them.
No obligation.
In view of the disposal of the writ petition, in view of the disposal of the writ petition number so and so, the IA stands closed, and disposal.
Duly obliged.
May I please, my lord?
Yes.
My lord, matter may be kindly pass over for time being.
No, what is why this is listed today? Listed for what?
Affidavit has to be filed in WPC. Item 14.
Yes.
My lord, I have been instructed to pass over the matter, ma'am. Kindly.
Earlier counsel withdrawn.
Who is appearing?
Deep Angin, my lord.
Let us see.
May I, Worship? We have filed the affidavit. Worship.
Dusty.
Yes.
Or respondent number?
182, your lordship. 182.
On Mr. So-and-so, learn counsel for the,
Lordship, there is an interim order that may be continued.
just wait, we'll just close this, learn counsel for the petition. When did you file this affidavit? It has not been taken note. Affidavit regarding proof of this upon respondent not yet filed. Huh. An affidavit is filed. Affidavit in proof on affidavit with regard to proof of service of notice upon the respondent number 3 is filed. Where is the receipt? Who has received this? Respondent number 3.
Yes, Lordship.
Perusal of the notice reflects that the respondent number 3 has received it. Respondent number 3.
Yes, Lordship.
What is the name of the respondent number 3? What is it? The notice annexed to the affidavit reflects that the respondent number 3, namely Miss Techi Ansi, has received the notice listed accordingly. The service of notice upon respondent number 3 is complete. Huh? Then wow. Yes, you have filed the affidavit.
Yes, Lordship, we have filed your.
Okay. As free for the by the non-council parties. You record her name also, huh? Be bound for respondent. Judicial. This is the matter for admission after 2 weeks. No?
Please, Lordship. This is a promotion matter, and since more than 1.5 years already gone, respondent has not appeared. There are 2 respondents, private respondents. One is already acknowledged the receipt of the, but another one is, though he is still serving as a superintendent engineer, I don't know how he is not receiving the.
You take present steps in that case.
Lordship, I heard that this 30 of this month, he's going to retire. That's why he is not taking any interest. Of course, now, moreover, even government also not yet filed the almost, because this was petition was filed in the month of December 2023, and since then no affidavit has been filed.
You file it. You take present step whether he comes or not. We'll see.
My prayer is that if he is not interested at all,
no,
maybe
it shows that there's no service report. At least service report should be there. Appearing is not an issue. Whether it is to be shown that he has been served.
See, every time I'm sending the notice in the office of the chief engineer where he is posted, till today he is there. I don't know intentionally. Otherwise, I can go for the publication in the newspaper.
That will be too
I
again
don't
part.
want to take such a.
You take a dusty. Have you taken dusty? No.
No.
Not you. You get it.
So if you're going to retire on 30th of this month,
You
then only 3 days left.
You take by tomorrow dusty, and then affidavit will be required. It's for promotion.
Yes,
Promotion matter.
yes. Subsequently, I got promoted also. Anyway, I'm now in the post of SC
Ha.
because two juniors were promoted based on the DPC report.
So you are not claiming any relief against this respondent number 4? If you are claiming, you have to. There's no way out.
No,
Any
because
relief against?
That's why I made them as a respondent number 4
So
and 5. So
there's a relief against them.
yes.
So you take the
Anyway, I will take it
by tomorrow.
Oh yes.
All right.
Yes.
And in the meantime, I mean, only take it after 2 weeks, and they'll file the.
One prayer, Lordship. This may be listed in the admission hearing so that we can dispose.
No. First, you have to take this thing. Not Mr. M, but learned counsel for the petitioner and MS Arbasar learned state counsel. Correspondent 1, 2,
1, 2, 3.
1, 2, and 3. Service in respect of
Number 2 and 3.
resistive.
Yes, Lordship. Upon
You want to take
for the petitioner.
on the prayer of Mr.
E. Paying, Lordship.
E. Paying and counsel for the petitioner.
And Lordship, we have one more prayer. That's the service also.
No, Mr. E. Paying and counsel for the petitioner is permitted to take resistive by registered for so and so, as well as dusty mouth within 2 days. MS so and so, so and so. Who is appearing for what?
Correspondent number 1 on appearing on behalf of the SGI.
Right.
I'm appearing on behalf of our city, standing counsel for the highway department. Number 5 and 7.
Are present, huh?
Okay. I would like to express one thing, okay? Exponent number 7 is filed with counter affidavit. And this affidavit will cover the counter.
Okay, we'll see. So in respect of respondent number
2 and 3.
You are for 1.
Lordship, I am for 1.
You are for 2 and 3, yeah. In respect of steps for 2 and 3, huh? This word.
Yes, 21 and 22, Lordship.
What is for 21?
Lordship, it's an IA. Lordship, we have filed this IA for correction of some words that were inadvertently written in the main petition.
Huh?
We have filed this IA for correction of some words in paragraph 5 and 6 in the main petition, 235, WPC 235 of 25.
Amendment.
Yes, Lordship, some correction. There were some corrections, Lordship.
Any objection?
No, Your Lordship.
Heard Mr. E. Paying counsel for the petitioner, the applicant, and and also heard Mr. MS P. Pang, London State Council. as well as not in IA. Okay, then it's IA.
And Lordship, as per order dated 03/04/25 in WPC 404. Respondent number 1, 2, 4, 5, and 6 were supposed to file their AIO affidavit.
Let us first dispose of the IA, sir.
Yes.
This is an application seeking correction of the inadvertent words written in paragraphs 5 and 6 of the assignment fix of the connected writ petition being WPC 235 of 2025.
Lordship, we were directed to change make the corrections.
Sir, let me pass the order. Having considered the submissions and the of learned counsel for the parties, and no, having perused the contents of the application and also consider the submissions of and having considered the submission learned counsel for the parties as well as the prayer for correction of the words as well as the prayer for seeking correction of the words written inadvertently in the petition being not objected to by the learned counsel for the respondents. I deem it appropriate to allow this application. Accordingly, the applicants are directed to are allowed to correct the words, namely, page 7. At para 5 and 6 of the writ petition. Understand? The petitioner, the applicant to file a corrected copy which may be corrected copy of the corrected copy reflecting the the petitioner to file the corrected copy and be allowed to be incorporated in the relevant paragraphs. That will do. You file a corrected copy and incorporate it. I dispose of, I dispose of. I is disposed of, sir. In writ petition. Further 3 years, hard Spencer. How many?
Your Lordship, I mean,
How many months?
in WPC number 404, Your Lordship, we have filed our counter affidavit.
404?
Yes, Your Lordship.
Yes. So,
And in item number, the WPC 235, we
heard
need some
Mr.
more time, Your
Spencer.
Lordship.
this will cover.
Yes, Your Lordship.
This, the affidavit which you have filed in the item, writ petition 404 will cover the writ petition 235. That's what I'm trying to say.
Ye-
Oh, you want some time?
I need some more time, Your Lordship. I have
Okay.
to check, Your Lordship.
Heard Mr. Swensel and consequently. MS P. Pangolan State Council submits that she has already filed affidavit in opposition in WPC 404 of 2024. Her was pressed for and is granted 3 weeks time to file affidavit in WPC 235 of 2025. List after 3 weeks.
Oblige, Your Lordship.
You want to file affidavit, any affidavit? Okay, so and so appears for the respondent number 18 WPC 404. 404, huh? Yes. Okay.
Oblige, Your Lordship.
Wait, wait, wait.
Yes.
This contempt, my lord, was filed for non-compliance of the judgment by the single judge. In the meantime, my lord, we had filed an appeal before this honorable court. Though the appeal was dismissed, we were granted liberty, if your lordship may have, page 9, second last page. Para 29. However, the liberty granted by the said judgment will still be available to the appellant bank to initiate proceedings de novo. This, however, clarified that such de novo proceeding would be from the stage of submission of the inquiry report. So this we have done. And accordingly, my lord, now the appellant has been dismissed from service. There is a
So
I'll
That's
get
the new
instruction
code of
tomorrow.
Ah.
Tomorrow.
tomorrow.
Let me get instruction. That's right.
So then writ petition is what?
Writ petition was that so-called notice that we gave pursuant to the liberty by this court, that is under challenge.
Okay. That cannot be also.
Since there was
That cannot be
no
also.
Cannot be.
That cannot be also. You may challenge this.
Yes.
That is
I'll
on
get-
merit. That too on merit.
I'll get instruction.
And it's very difficult to look into the merit also.
Tomorrow, man.
Okay. On the prayer of Mr. Ketam, learned counsel for the petitioner. List this matter tomorrow, huh? List these matters, huh? Tomorrow.
Highly obliged.
Tomorrow only for withdrawal? I
Uh,
mean, closing of the contempt petition
just-
and the withdrawal of the writ petition.
I'll just get the instruction.
Isn't it?
It was given long time back.
Ah.
They received it.
And then you just read, Mr. Deepang, non-counsel will respond with this present, huh? Hmm. 23. Yes,
Lordship,
affidavit,
I filed today.
huh?
I filed today.
Okay. You have filed or you are filing?
I have filed.
Received.
Okay. You have received.
Received.
Uh,
Today by today. sir.
Heard Mr.
Big-
All are represented.
Yes, ma'am.
Yes.
Learned counsel for the petitioner. Mr. B. Pitcher, learned standing counsel. Are they?
Yes. Yes.
You have also filed.
Yes.
And Mr. Learned counsel for respondent number 4 have submitted that they have filed their respective affidavits. Mr. List for admission hearing. Admission after 3 weeks.
Madam.
Hmm. It appears
My
to
lord,
be
will take each of us 10 minutes.
Madam, item number
25 may be taken past because item number 24 will bearing on the consequence of the item number 25.
It appears to be this familiar with this name of the petitioner.
Yes, no.
What is the matter?
Matter is my LPC land portion certificate was cancelled without giving an opportunity of being heard. My lord. One will find the interim order at phase 18, my lord, 1/8.
Judgment and order.
Judgment and order, my lord.
Judgment order, yes, by the deputy commissioner.
Deputy commissioner, my lord. May I read, my lord?
Yes.
Judgment Sri Kagonye versus State of AP Endorsement. The All Zero Market Hotel Committee Zero submitted a petition memo number so and so dated 33/2015 before Deputy Commissioner Zero with a prayer to cancel the land possession certificate of Sri Kagonye issued to him by DC Zero order number so and so dated 15th August 2009 for 1,729.70 square meters at Kandu Area 0. Only recently, while pursuing the encroachment case of All Zero Putu and Suluya, the alleged LPC of Sri Kagonye, so on of so and so, had come to the light in the backdrop of the hearing stage of an appeal for quashing and setting aside of interim order by dated so and so, passed by the ADC, State Officer Zero. The contention of the All Zero Market Welfare Committee Zero was that the alleged LPC was issued in All Zero Putu area, which is a GOP land, and not in the private land as claimed by Sri Kagonye. Part of the plot of land against which the alleged land portion certificate was issued to Sri Kagonye is found to be the overlapping with the plot already allotted and occupied by the Zero Electrical Division, Department of Power Zero, for switchgear of Electrical Department Zero. Part of the representation was also received from the Executive Engineering, Electrical Division, Department of Power Zero, by its letters so and so dated 31/3/2015 requesting for cancellation of land possession certificate issued to Sri Kagonye since the alleged land possession certificate falls within the land allotted for so and so substation at All Zero. Moreover, land measuring so and so square meter was allotted to Executive Engineering, Department of Power Zero for establishment of switchyard in the year 1998, which was much earlier than the alleged LPC, which was issued in the year 2009. Are the parties versus the case record? As per the alleged LPC records, the plots fall within the Kandu area, whereas the All Zero Market Welfare Committee Zero has claimed that the plot of alleged LPC fall within the GOP revenue land of Zero Putu and overlaps the already allotted plot of switch yard area of the Power Department Zero. A circular road constructed by the PW Department running around the base of the hillock at All Zero area marks the boundary between the All Zero Putu area and the Kundu area. The All Zero Putu area which falls above this circular road is GOP revenue land, whereas the land below this road is a private land which includes Kundu area. Since there was a contradiction in the claim of the parties regarding the exact location of the plot of alleged land possession certificate, a physical verification of the location was carried out by the court in the presence of the board of parties in the office of the Power Department on 27/7/2015. On physical verification, it was found that the plot of alleged LPC falls above the PW road within All Zero Putu area, which is a GOP revenue land. It does not come within the Kundu area, which is a private land area falling below the PW road. Moreover, the plot of alleged LPC overlaps the already allotted land of the Zero Electrical Division, Department of Power Zero. The Department of Power Zero has already established switchyard at the plot. Moreover, the Power Department Zero had constructed many quarters and bachelor barracks at the disputed plot to accommodate its staff. Sri Kagonye has got no any structure at the site for a bamboo fencing to show his occupation, wherein also 3 MIBT structure of the Power Department stands. Moreover, LPC issued against only to the private community land. It is not issued in the GOP revenue land. All Zero Putu is GOP revenue land. Only land allotment order is issued by the GOP government land, revenue land after following due process procedure. After considering the above discussion, I am of the view that the LPC number so and so issued so and so dated so and so Zero Putu area was wrongly issued to Sri Kagonye. Sri Kagonye had hidden many facts about the status of the plot before the authorities while applying the order LPC against this plot of land. Therefore, I find it appropriate to cancel the LPC number so and so issued to Kagonye. Hence, the other land possession certificate will have no any locus standi. The alleged land possession certificate of Sri Kagonye is hereby cancelled and may be treated as withdrawn by the company authority. After reading this judgment also, my lord, natural justice has been violated. Nowhere it has been reflected the submissions of the other parties, my lord, the private. So there is no reasons over here. And what happened here?
No, reason is very simple. It is a government land. You have been wrongly issued the LPC.
No, my lord.
And the LPC is only issued to a private land.
Yes,
not to the government land.
Yes,
Which has been already issued.
yes, man. I have been issued.
The allotment is already given to the government department.
No, man.
Electrical department.
Even I have filed.
How do you know?
My
It is
lord,
the record filed
I have
with
filed
the
RTI.
commissioner.
In their RTI reply also that said there is no record as such, my lord. In my affidavit reply, I reflected that also, my lord. So, my lord, before cancelling, at least before cancelling the LPC, I should have been given opportunity, my lord.
No opportunity. They have in your presence, this was inspected.
No, my lord. When they are, my lord, initially what happened? They have issued a notice under Arunachal Pradesh Unoccupied Eviction Act, my lord. Then when I brought my LPC, the notice of the concerned authority, and this private respondent jump into the area, jump into the scene and lodge a complaint that I have encroached the government land, my lord.
They are not getting any benefit.
My lord.
They are doing it for the public. Already this substation, what are there?
Power, but switchyard, my lord.
Switchyard, all
yes,
these are already constructed.
No, my lord.
How do you know?
My lord, I filed RTI also, my lord. My lord, may come to my affidavit reply, my lord.
What is the area? How many? How much?
1,000.
1,729
Yes, ma'am.
square meter.
Yes. It is clear case of violation of natural justice, my lord.
What?
Opportunity of being heard, my lord. For the altered pattern has been violated, my lord.
Heard the parties.
My
You are
lord.
not there.
My lord,
Why are you not there?
when the verification was done, my lord, the members of the zero committee, they were so much crowd. This I have been not allowed to even hold out a single words, my lord. At least, my lord, representation, I should be given chance to submit the representation also, my lord.
You were heard here. What do you mean by opportunity?
My lord, in the order itself, nowhere reflected what my submission is, my lord. What my submission was, my lord. Nowhere it is reflected. It is even this order cannot be the original order, my lord.
Your submission, just not recording your submission. How can you that it's not been provided? You have been heard.
No, my lord.
You were there.
When the spot verification was done, I was there, my lord. That's accepted, my lord.
It's recorded.
But the,
Heard the parties. Where is the case record?
no, after the spot verification, my lord, there was no hearing at all, my lord. Then after 2 months, they issued this cancellation order, my lord. At least verification report should be there, my lord. After verifications, there was no hearing at all, my lord.
Yes. Who is for what? Who is for Deputy Commissioner? Who is for whom? Yes.
There is a street here of the our department already. In parallel, there we have stated that the LPC has been obtained fraudulently by the petitioner. So it has been cancelled after hearing the petitioner and after conducting of the export physical verification. It has not been cancelled without hearing them.
When 2007, on 2006, I applied for LPC, and it was LPC was issued in 2009 as per the, my lord, procedure, my lord, memorandums of their memorandums. So how they can now say that was issued? And what kind of, my lord, I have concealed the tax, my lord. Nowhere it's reflected in the order, my lord.
But PEX is a government land.
No, my lord, private land. So even if I should be given,
Then you file a suit. Because this LPC doesn't create a title. Even if we set aside this cancellation.
no, as per the office memorandum, the private, who have got the private land, they have been issued LPC, my lord.
What?
Owner of the private land
Yes.
is to be issued, my lord. So here I am the owner of the my lord, land.
Owner of the land is issued, but doesn't create a title when it is disputed.
No, my lord. I'm not this on this will be disputed fact, my lord. My only here concern is in this writ petition is natural justice has been violated. My lord.
That has not been violated. You were heard, you were present during the sport verification.
No, my lord. After sport verification, there was no hearing at all, my lord. At least I should be given opportunity to submit some representation also, my lord, to some documents also, my lord. Nothing was done, my lord.
Then why the DC has to write this is clearly given.
And moreover, my lord, why they initiated this LPC? Because all zero market welfare committee, they have some interest on that property, my lord. Because all zero market welfare committee is not a legal entity, my lord.
Forget about them.
So anyway, my lord, if I should be given proper opportunity, my lord, so I will press my case, my lord.
What more opportunity? You had in your presence, the physical verification was conducted, and then you were heard.
During the physical verification, my lord, I was never heard, my lord. I was present in the physical verification. After that, there was no hearing at all, my lord.
And I just said, also.
My lord.
79. You have filed an affidavit in which case?
In both the
79, what you have said?
I have done the notice already before with regard to this topic, land. And as a one.
This is by where it is, page number, respondent number.
Affidavit of warrant.
1 and 2. 2 and 3. Yes. Yes.
Here comes matter also. The honorable for directives for verification.
Same lane. Same length.
Yes, also. Here also the all the committee were also here. Yes, Joseph, this is with regard to the zero photo. Zero photo only. In lots of case 12 also. Case 12. And the beginning of case 13. It's myself. This is of course singing and certified that zero people will belongs to the people of Tamil and Thailand plants with them. in some of this, the head of the civil process, the suit surrendered to the This has been donated in the year also by the people of this area in 1952 also. So they don't want that some private persons who not to get LPC out from the land.
Yes.
Even no notice was issued, my lord, regarding cancellation of my LTC.
No, thereafter, this deputy commissioner has passed the order. Consider it. Submit the clause for the deputy commissioner, one from one receipt also.
Judgment order passed by deputy commissioner, my lord. Boundary area is also not specified.
You're a party here.
No, I was not party member.
This Zero Putu and Kundu is different place or what?
Different place. They are adjacent, my lord. Zero Putu is yes, adjacent. No, my lord, at least I should be given opportunity to properly represent, my lord.
Sir, you have been given.
No, my lord, that is not the proper opportunity, my lord. As per my understanding, my lord. Though I was present at the time of verifications, but there should be given some opportunity, my lord, to place my grievances, my lord. And there was no notice at all to cancel my LPC, my lord.
Whether he was heard or not.
From the statement, I can make out that he was hard. Accordingly, that's why physical verification was also made.
Initially it was. Initially notice was given to him. Notice also given to him when they decided to go for a physical verification.
Yes.
Thereafter, you have passed the order. Yes. Would have been given him a notice. But it shows that hard the parties. No name, nothing.
Nothing. Simply hard. When it was hard, it's nothing, my lord. When it was hard, it should be reflected, my lord. When hearing was done, my lord.
The method is very simple. If he was heard, method ends there. If he was not heard, you'll have to hear and pass the order. Although it appears to be a mere formality.
Well, I should be given proper opportunity to represent myself.
The deputy commissioner on physical verification found that it's a government allotted, government land. Then how do you dispute it?
No, earlier deputy commissioner also verified, my lord. Earlier deputy commissioner when my LPC was issued, they have also verified.
Doesn't create a right title.
My lord. Natural justice, my lord.
Yeah, let her find out. There's a simple matter.
The record also.
If he was heard.
He was heard, my lord.
So
he was heard. It is reflected in the order seal also. Even we were present, representative of all Zero Market Welfare Committee.
No, my lord. I was not when it was heard, my lord. Then, when it was heard on same day, my lord. When order was passed. No, my lord. Before physical verification, my lord. Notice for physical verification was issued. Accordingly, I was also present. They were also present, my lord. And they verified. What they verified, I don't know, my lord. Then after this order came out, after 2 months, my lord. At least what report was there, at least I should be.
When have you made your statement?
Yes, my lord.
That after verification, the
previous page may be kindly seen.
Which one?
Page number 17 of read petition.
Of which read 456?
Read petition.
456. There are two read petitions.
No, no.
2015.
2015 one.
That's why I'm saying
Item 24.
456.
24.
Page 17.
Page 17.
No, this is hence a feasible verification will be carried out in the presence of all parties at this so and so and way. Request
And
that-
this copy, it was his copy.
Hmm.
My lord, kindly down below copy to Kagonyime.
Hmm.
And next page is the judgment and order.
Hmm. 7
So
September.
when he was present there during the verification, and
No,
here
that's why I'm saying during verification he was there, but then he don't know what type of verification was there. But then after the verification, this order came on 7th of September. That is what he's trying to say.
Para at my para at my can see, madam. That on 23/7/2015, the respondent were rapidly visited in the disputed area and went back without any proper measurement. The deputy commissioner came with the budget committee members and officials of the power department. They were busy in themselves and did not hear suggestion, clarification, or information of the petitioner. Thereafter, matter was kept pending for about 2 months, and all of a sudden, the interim order letter so has been issued by the deputy commissioner, whereby the LPC so has cancelled, madam.
Partially, my lord, I have raised the maintainability of this writ petition.
Saying what?
On the ground that even if we fair use the pleadings in the writ petitions, is coupled with serious disputed questions of fact. They themselves are saying. And in similarly situated matters, there are some other matters of Zero Putu area wherein all Zero Market Welfare Committee was party. If my brother agrees, this honorable court has dismissed with a direction to approach before the civil court. If my brother admits that in a similarly situated cases, my lord. Because when you are saying this is private land, as per the deputy commissioners on physical survey, this is a government land. And therefore, since the LPC, it was overlapping, it was cancelled. And my lord, kindly in that earlier order also, it is reflected. The government council has just shown one document. In my, it is reply by 1 and 2. Anyway, that deputy commissioner order, my lord, page number 4. Married. The page number 4.
No,
Second.
no, that's not the issue.
My lord, let me kindly read this one. After careful perusal of written evidence and examination of witnesses, it becomes clear that there is no dispute that the land in question was given to government in 1952. My lord.
By whom? That is by whom?
By next sentence, my lord.
No, that is which order?
This is by the deputy commissioner.
Pursuant to the order of this court.
Pursuant to the order of this court, my lord. In writ petition number 3 of AP 2001. Pursuant to that, there was some verification. Wherein, my lord, it is observed. May I continue reading, my lord? That the land in question was given to the government in 1952. Next sentence. When Taru Kago Layang clan members, and this petitioner is from Kago clan members, were asked on their contention that government has illegally allotted the land, they could not give any satisfactory reply. Now, next sentence, my lord, very important. On physical verification also, it is apparent that members of all Bazar Committee, Zero, have not appropriated the land illegally as claimed by Tarukago Layang clan. Only there is a 132 kV switcher owned by the government and video office is constructed on the land. Herein also, my lord, during those days, my lord, the finding, 2002, my lord. So meaning thereby, my lord, that 132 kV switcher that was existed in the year 2002 also, my lord. This is very clear. And my lord, when writ petition itself coupled with so many serious question, disputed question of fact, it is the civil court to decide best, my lord. For example, if suppose he is given opportunity also, what will he say, my lord? So similarly situated, some other petitioners, they have also approached this honorable
If
court.
my deputy commissioner, had deputy commissioner been given opportunity, this disputed question of fact would not become material, my lord. So I am saying, let me represent properly at the deputy commissioner, so that there can be disputed question can be settled here, my lord. So I am only violation of natural justice here, my lord. My lord, regarding violation of natural justice, my lord, 2003, on citation 4 SCC, paragraph 15, my lord. 4 SCC 557, paragraph 15, page 7, my lord. Paragraph 15. Married, no? Paragraph 15, my lord. The adherence to principle of natural justice is recognized by all civilized states is of the supreme importance when quasi-judicial body embark on determining the dispute between the party or any administrative action involving civil consequence is an issue. These principles are well settled. The first and foremost principle is what is commonly known as OD alter partem rule. It says that no one should be condemned unheard. Notice is the past limb of this principle. It must be precise and unambiguous. It should apprise the party determinatively the case he has to meet. The time given for the purpose should be adequate so as to enable him to make his representation. In absence of notice of the kind and such reasonable opportunity, the order pass become wholly vicious. Thus it is but essential that a party should be put on notice of the case before any adverse order is passed against him. This is one of the most important principles of natural justice. It is, after all, an approved rule of fair play. The concept has gained significance and sets with a time. So, my lord, I should have been given proper opportunity, my lord, to represent. Similarly, my lord, our bench, our court, this court is also similar kind of nature, my lord, LPC, where natural justice has been violated, my lord.
Obviously, but then there we don't find any violation. You are heard.
Yes, my lord.
You are heard.
No, my lord. Simply they have reflected in their order. If I was heard, what was my submission? At least that should be reflected, my lord. And paragraph 7, my lord. This GLT, my lord. Admittedly, LPC was issued in the name of the petitioner after conducting an inquiry in due process. NOC was issued by the respondent number 3, DFO, and it is to be presumed that it was also issued after proper inquiry. There is nothing before us that the LPC was obtained prudently. Para 7, my lord. Page 65, my lord. Para 7, my lord. Admittedly, LPC was issued in the name of the petitioner after conducting an inquiry in due process. No NOC was issued by the respondent number 3, DFO, and it is to be presumed that it was also issued after proper inquiry. There is nothing before us that the LPC was obtained prudently or misrepresentation of the fact. If the respondent subsequently found that the land under LPC or any party thereof was its forest land and that LPC should be cancelled, it was the bounden duty of the respondent to issue a so-called notice to the petitioner and to hear them on the issues. The principle of natural justice in the case at hand was surely violated, and the action taken by respondent, in my considered opinion,
As to
definitely
whether the principle of natural justice is violated or not is to be taking into consideration the particular fact of the given case.
My lord, substantially, my lord, what they are only saying I was heard. And when I was heard, it was not reflected, my lord. And what was my submission, my lord? To be a reasonable order, my submission should be considered, my lord.
What is your submission?
No. At present, my lord, it will be
Simply saying that it's a private land.
private land, my lord, yes.
So as
I've constructed the,
forget about this,
Yes, ma'am.
the LPC. So as that it's a private land.
because my lord, other than that, in our community, my lord, there are no documentary
What can we do?
evidence, my lord. At least, even though I have illegally occupied, my lord,
At least the verification has been done in your presence.
I am saying that the verification was
Done.
not hurt me, my lord. Not hurt me, my lord.
Verification, you were present.
What I oppose, they did not consider, my lord.
Yes, anything to show that he was heard before passing this order?
And
Any
clear
kind of notice? Verification, no issue. He was there.
Verification he was there, and then when order it says all the parties heard.
But then it is
Yes,
decided
because-
after the verification, this is decided, order was of after 2 months. You should have at least issue a notice, I mean, the deputy commissioner. It will be, I think, mere formality, even if we set aside also.
Therefore, I'm-
Ultimately, what you can do? What, how
Title,
you will,
title,
how
title
you
suit. Ultimately, my lord, I will go for
Title
title
suit.
suit, my lord.
That's what I'm saying.
What's there?
Civil code, there is a
Cancellation doesn't
remedy.
make any difference.
Yes, my lord. This,
Even if it is cancelled,
yes,
you cannot, the establish your title. If it is not cancelled,
yes, ma'am. Yes, ma'am. That's true,
you
ma'am.
cannot establish your title just because of the LPC.
That's true, madam. But before this court is the violation of
Because
which
it doesn't create a title,
Yes, ma'am.
LPC.
LPC does not confer the titles, my lord. That's that's true, my lord. But my
So
lord,
there is nothing. We'll send it back. Hear him.
and my lord, next that's item
Hear
number,
them and pave way for filing
Yes, item
title
number-
suit.
my lord, item number 23, my lord.
Hmm.
The same plot of land, under same plot of land, the private respondent was allotted on 2022.
Hmm?
During the pendency of this writ petition,
Hmm.
the deputy commissioner issued another land allotment to the private respondent.
Hmm.
And
That I will dismiss.
yes, my lord, because if this succeed, my lord, cancel that is cancellation order, LPC cancellation order.
We'll provide them the only ground of appears on the ground that you have not been, it appears to have not been, you have not been heard. It appears that you have not been heard.
Yes, madam.
Deputy
After
Commissioner
hearing,
hearing within issuing a notice of 7 days, pass an appropriate order.
yes, my lord. If I succeed, then if my lord dismissed my request,
Then you cannot succeed. I'm sure you will not be succeed unless you file it.
My lord,
My
I am
lord-
representing.
just one, my lord. During the pendency, there was an interim order, my lord, not to evict me, my lord. On the strength of this interim order, my lord.
Huh.
Then during the pendency, then
You have been evicted.
just like that, my lord, they started labeling the my lord land.
You are for in the
I am in the this 79 writ petition, my lord.
17, yes.
Yes, I am there, my lord, private respondent.
Hmm.
I am the, my lord, I am representing this Apatani Pensioner Welfare Association.
Hmm.
My lord, my case is slightly different. So far, what he is saying that his allegation is that the land which has been allotted to me by the government, that's to the provisional allotment, my lord, for the establishment of our office, my lord.
Hmm.
Now he is saying that that land falls under his LPC.
Hmm.
But I am here, my lord, differing from him. Because, my lord, if see the allotted land, my provisional allotment, it says 0 Putu area.
Hmm.
And his LPC is saying
Kundu.
different area.
Kundu.
My
Yes,
lord,
yes.
government affidavit is there. Government is
Yes.
admitting that
Okay,
the allotment same area, my lord, same plot.
Now, first point, my lord, this has become a disputed question of fact. Now, another ground, my lord, as long as back, my lord, in the 18/10/2002,
Hmm.
2002, my lord, the pursuant to the judgment order passed by this honorable court, my lord.
Continue, Monday.
But Monday, I will be out of station, my lord.
Then
Affidavit
Tuesday.
in their government affidavit.
Wednesday. Any day next week. Since you have spent considerable amount, we're not going to release.
My lord. I'm free, my lord.
Vacation.
No, no.
Anytime, my lord, I'm free.
Or tomorrow also, my lord. Tomorrow, 10 minutes. For my part.
Huh?
I have one, my
my
lord,
part,
already.
For me also, I won't take much time, my lord.
Okay then.
Tomorrow.
10 minutes, 10 minutes.
I won't take even 10 minutes, my lord.
Ah.
My lord, first, my lord, it's a case I'll just bring. First, my point, my lord, short, in brief, I will submit, my lord. First, my lord, the lane which has been provisionally allotted to me, it doesn't fall under the LPC lane. Because this is a disputed question of fact. Second, my lord, now the lane which has been allotted to me long time back in the year 2002, pursuant to the order passed by this honorable court, the deputy commissioner has passed the judgment saying that the people, local people of that area, his clan, Cargo clan, they had donated in the year 1950 to the government. And it is on, there is in the record, this judgment, my lord will find at page number 16, annexure E. So, long time back 2002, this has been decided that this is a donated land. Once it is donated, my lord knows that this has become a government land. Now, and my provisionally land which has been allotted to me, it is within this donated land, donated by them. This is my another, my lord, ground, my lord. Now, so far his claim is concerned, my lord. My lord knows that LPC doesn't confer any title, my lord. Now, in his writ petition also, my lord, where he has shown anything to the satisfaction of this honorable court that he is in the possession of the land even, my lord. And my lord, so far the principle of natural justice, I'll just submit, my lord. This is not something, my lord, inflexible concept, my lord. This has a very flexible concept in the sense, my lord, only for the sake of hearing, my lord, this natural justice, you cannot insist for it, my lord. My lord, this hearing here, at least he has to satisfy this honorable court, this my lord, that my lord has seen that there is on the record this government establishment, all these things are there, my lord. Now, only at the saying, my lord, he has not come with any materials to so establish that either he had a possession or he has a possession of that. But so far, my case is concerned, my lord, it has nothing to do with his this LPC land, my lord. It is a completely different land, my lord. And I have been allotted only, my lord, small plot of land, my lord. It's not a very big area. It's to the Pensioner Welfare Association, my lord. We are very old people. It's, my lord, only 337 square meter, my lord. My lord has seen, my lord, find page number 11, my lord. This provisional allotment he has put into charge. And it is a highly disputed question of fact. My lord knows that my lord is sitting as a reed court, my lord. Of course, in some situation, disputed question of fact can be seen, but when the question of rationality and irrationality
This
comes.
LPC was state. Cancellation was a state also.
State.
No. Cancellation of LPC.
Not state. But on the strength of that cancellation, I cannot be evicted.
That protection has been given only that on the cancellation of the LPC, that eviction should not be done. On other ground that can be done, but no stay has been.
Cancellation welfare should not be made the basis for eviction of the certificate holder. Yes. There is no bar. You will not be evicted.
Yes.
What you require?
My lord, they have
only
occupied and started
1 square meter.
And my lord, under a submission, my lord. There is
yours is 100 and?
My lord, 340.
340.
Small land.
Your LPC is 1700.
700.
And you are saying that it's not this, the claim, the land?
No, my lord. My land falls
which,
under, my lord, judgment dated 1810-2000.
Falls under 042 only.
Yes. It falls under, my lord, kindly turn to page 16.
My lord, affidavit of government is clear, my lord.
So 24, this writ petition 79/2022 is dismissed, and writ petition 456/2005, I'll pass the order.
My lord, their affidavit, government affidavit. My lord, government.
Except for this notice for verification, there is no notice, right?
For hearing.
For hearing. There's no notice.
No notice.
Except for this verification, huh? Yes. Before this order was passed.
Outcome is so apparent, my lord, even then. Outcome will be the same only.
No problem, my lord.
How he will.
But it's a cardinal
My
principle.
lord, my
Yes.
lord.
Cardinal principle we cannot ignore.
Since he has knocked the my lord's
But
door.
let me see. I'm not sure.
My lord, in other cases also,
It
government
depends-
same plot of
It's
land.
not all the cases. Principle of negligence. It depends on case to case.
Yes.
I'll find out.
It's only because of my lord's big heart only. I think he has been accommodated.
We'll see. No, I'm not decided. I'll pass the order. You'll get the order. I'm not
Deeply-
making it CAB, yeah. I'm passing an
Right.
order. When you will get, I don't know.
Certainly will go against the deputy commissioner, if pass against me, will file for title suit. That is there.
Huh?
my lord. That is
And my
there.
lord, even alternative remedy as per Arunachal Pradesh record is
If
that
my
is
lord,
also there.
if my lord
He has
declares
invoked that
in
one
this
also.
petition, the land is government, then I'm barred to go for the even title suit also, my lord.
Hmm?
If my lord in this petition declares this land is government land, then I'll be barred to go for civil court also, my lord.
No, court will not declare. Na?
I cannot.
Yes.
DC has already declared.
It is not maintainable.
Unless sitting as a appellate court of a civil matter.
Yes, my lord. That's true. man. So my simple prayer is set aside that's a order and liberty will be given to the authority council, my lord.
Deeply.
Hmm.
File your list.
How like?